Hey folks, welcome to Role of Law. Hopefully that intro went off without a hitch. Hopefully that didn't destroy anyone's earballs, but all right, how's everyone doing? We having a good day? Yeah, I really hoped this channel would be more sort of lighthearted, non-legal content, but here we go. I guess we're going to have to do some legal discussion on all of this. So what we've got here, and just for, the reference of people who might not be following along, Wizards of the Coast is replacing the open game license that we currently have that has been pivotal in ensuring that Dungeons and Dragons has a sort of vibrant third-party ecosystem. And now they're replacing it with what they call Open Game License 1.1, which is actually not an open game license at all. It's a completely different license, and it is very restrictive. So let's have a look at what's going on, because we've got this leaked document. Now, my previous videos were out discussing sort of the leaks as reported by other organizations, and they sort of focused on a few specific clauses. Now we've got the whole document. And so because we've got the whole document, we're going to go through that. Some people have said things like, how do we know this is authentic? This has been confirmed by multiple people as the document that they have received. And I've read through it. Quite frankly, it looks like a real document. It looks like this is, the genuine thing, because this would take a lot of work to go through if you were just doing it as a prank. Like, this is not something you do just to casually screw around when it's 9,000 words long. And I mean, it's written in sort of the proper format. It doesn't look like it was drafted by some guy who's just having a laugh. So yeah, we'll have a look at it here. I see an excellent question. When do the Ian Tries a New Game System streams start? I've already got streams that are on Stars Without Number, which is here somewhere on the floor. I'm going to be doing some streams to talk about some other game options. This is one of them. I've got Mutants and Masterminds over there, so I'll be doing some streams talking about other games people can play. And yeah, we'll go from there. The big thing is that I had planned to start a D&D campaign, and I'm not going to anymore. So that is on the back burner. All right, let's have a look here as we bring this up. Hopefully everything goes just fine, but we'll have to see. There we go. Hopefully we've got that going. So, all right. Now, it starts off with an introduction, and the introduction is basically just sort of a very casually phrased explanation of the actual, the actual license there. And I see somebody saying, be careful, Mutants and Masterminds is based on OGL 1.0. Yep. That's actually kind of why I rushed out to buy a copy, because I don't know if I'll be able to get it anymore. So, yeah. All right. And I am starring some questions here because they are good questions, but I think they're a little early at this stage. So, Dungeons and Dragons is all about creativity, both yours and ours. Throughout the nearly 50 years since the first release of D&D, Wizards of the Coast and its predecessor, TSR, have encouraged people to build new campaigns and material on the foundation of the Dungeons and Dragons base game. Historically, we have allowed fans, through our open game license, to make and sell commercial content using our intellectual property via the Systems Reference Document, SRD. This practice has continued for more than 20 years, and we continue to support it today. And Donna Parker, thank you very much for the very generous super sticker here. And you say, I ask, is Wizards now claiming that the SRD 5.1 is the only valid licensed SRD, that everything else is not in 5.1 is now unlicensed content? Yes. In fact, they go a little further than that. And yeah, lots of people are going to want to pick up stuff as we go. All right. A lot has changed in the last half century, including the rise of the internet, apps, Web3, and even virtual tabletop role-playing games. Now in 2023, we're updating the open game license to address some of these new realities and fix some of the loopholes and contradictions that made their way into the open game license during the time since its first release. Now, when they say loopholes, what they mean is that people are using it to create products they didn't expect, but most of us wouldn't think that these are loopholes. Most of us would think that these are, in fact, pretty awesome things that have happened. All right. So one aspect of that is dividing the old open game license into two pieces. First, a license covering non-commercial uses of SRD content, OGL non-commercial, and second, a license that applies to commercial uses of SRD content, OGL commercial. So this is actually two different licenses, and we're going to go through both. The OGL non-commercial and OGL commercial together make up the updated OGL. This revised license is intended to protect the D&D brand by reducing creator confusion, preventing bad actors from tarnishing it, and preventing large businesses from profiting off it without proper checks and balances. Now, the people tarnishing the D&D brand right now are Wizards of the Coast. Reducing creator confusion, I don't think is actually going to happen. I think it's actually going to increase creator confusion. And Canman, I see your comment here. I'm just starring it to respond to later. So the actual license is available through the hyperlinks below, although it seems that somebody went through those links and copied and pasted it. I like this comment here. So if you're comfortable with legalese, hey, I am, or somehow enjoy reading legalese, hey, I do. Feel free to jump ahead to those links. We're going to get there. We've included explanations and examples alongside the legal language to help make the OGL easier to understand and comply with. And in some places, they're getting a little overly cutesy. So we'll talk about that too. You can get to those comments by clicking the link after each section. If, on the other hand, you would like to start with a plain language of how the OGL works, you can start here with the FAQ section. In addition to that, we've included a set of comments in the license itself that accompany the legal language and provide explanations and examples to help make the license easier to understand and comply with. That's repetitive. Somebody should have caught that in drafting. Check. You can get to those comments by clicking the link after each section. That's weird. I'm not sure what's going on there. Below are a few FAQs about the new license and its parts. So, yeah, and I see this. Do you feel that the royalties percentages are set so high to take all the income from any company that's larger than 2 to 4 employees and force companies to stay small or downsize? I'm going to talk about that too. And Iron Flare, you are correct. We'll talk about that as well. All right. So, and there's a lot of questions we're getting. I'm starring most of them just so I can come back to them. Also, I'm just going to say thank you, Gail Schmidt, for the super sticker. It's much appreciated. All right, let's keep going here. All right. So below are a few FAQs about the new license and its parts. What is commercial use of SRD content? If no money or anything else of value is changing hands to get access to the things you create using SRD content, that's non-commercial use and is covered by and subject to the terms of the OGL non-commercial. If any form of payment or income for access to your work is involved or is specific to a particular work, even if it's just $1, it's covered by the OGL commercial. So what they're talking about here is if there's any form of paywall or any sort of limitation like that. Now, they say that they've got this cleared up. I actually think that they don't have this as clear as they think they do. We'll talk a bit about that when we get to the actual clauses. because right now we're just looking at their explanation of the clauses. And yes, Random Bari, I think you're right, but I will get to that as we go. So to be clear, crowdfunding a new project is commercial use. Accepting subscriptions or membership fees or Patreon patrons as a condition of accessing your work is commercial. Accepting voluntary donations via any tipping mechanism or sites where you're providing your content for free, regardless of those donations or tips, is not. If you're giving away your work for free on Patreon or otherwise and asking that people support your work if they enjoy it, that's not commercial. But your work must be given without strings attached if it's going to be considered non-commercial. So we've got this. They think that's clear. I can point out some situations that fall into some really interesting fuzzy gray zones. So what are my options for making D&D related content? If you're going to use SRD content to make tabletop role-playing games and game supplements on a non-commercial basis, the OGL non-commercial applies. If you're going to use content we make available for third-party use to make tabletop role-playing games and game supplements on a commercial basis and only want to use material from the SRD but not other material, like the Forgotten Realms setting, the OGL commercial has you covered. If you want to publish work that uses the Forgotten Realms setting or other content not included in the SRD, that's under the Dungeon Masters Guild. If you want to make videos or other content and monetize it via ads, that's going to be covered under the Wizards of the Coast fan content policy. Now note, the Dungeon Masters Guild requires giving them a full license to everything that allows them to use it for free. So that's, concerning. So does the fan content policy. And so a lot of this, I just, I'm not publishing anything under any of these licenses because they're so toxic. So what does the OGL commercial mean for me as a small creator? For most of the community's content creators, those making under $750,000 per year in SRD-based content. Now, making is interesting here, because most of the people who would be covered by this $750,000 per year aren't making $750,000 per year. In fact, you could be making your game at a loss and losing money and still hit this. So we'll talk about that as well. So the OGL commercial changes very little and is primarily designed to help us simply to know you better. Oh, isn't that nice? They want to know us better. Like the guy at the airport snapping on the rubber gloves wants to know you better. Yeah. Under the OGL, those creators will need to register their commercial content with us so that we know what's out there, tell us a bit about their products and product sales, and start adding a creator product badge to their materials so that everyone in the community knows they're publishing under OGL license from Wizards of the Coast. There's some reasons for that. All right, let's have a look here. Making Dungeons and Dragons is a labor of love for us, but it's also a business, which you're going to run right into the ground. We, like you, want to keep doing what we love and pushing D&D forward. We want to keep pushing D&D forward, but you guys are looking to move it back. Hopefully the pushback on this gets some executives fired. Just saying, because the only way this stops is if there is enough of a pushback and enough of a disaster that they really need to fire some folks over this. The open game license was always intended to allow the community to help grow D&D and expand it creatively, and it has tremendously. It wasn't intended to subsidize major competitors, especially now that PDF is by far the most common form of distribution. So, neat stuff out there like this, which is the Mutants and Masterminds book. They explicitly want to stop this from existing. They explicitly want to sue Pathfinder out of existence here. They very much want to destroy competition. That is exactly what they're saying here, is that they want to destroy competition. So moving forward, hugely successful businesses that generate more than $750,000 of annual revenue will also need to share some of that success with us by paying a royalty of 20 to 25% of the qualifying revenue they make in excess of $750,000. Note, When they say hugely successful here, there is no guarantee that any of these companies are hugely successful or even minimally successful or even not like absolutely losing their shirt on this. So, Proton, I see your comment there. I've got it starred. I will respond to it as we go. And all right. So, but even for those wildly successful creators, and this is not about wildly successful creators necessarily, they will not owe anything on any sales made before January 1st, 2024, no matter how much money they make in 2023. That's largely because they want to make sure that the accounting is lined up. If they tried to say, hey, in 2023, they would have a huge difficulty with doing that. So we're doing it this way so that creators have time to plan for the transition and adjust their business plans accordingly. No, they're doing that so that people have time to get the shakedown because there is going to be a shakedown. So we'll talk about that. All right. So how do I agree to the OGL commercial? Anyone publishing content under the commercial license will need to register that content with us by creating an account at dndbeyond.com, providing us with identifying information such as the name of the person or entity creating the work, the title of the new work, a summary of the work, and once the work is available to others, a copy of the work. So you got to give them a full copy of it that they can then mine for content. When you complete that registration, you will also be confirming your agreement to the terms of the OGL commercial. You can find the registration form here, and there's going to be a link. This is just part of the draft text, right? Because when they actually put this up online, they would have a link there. All right. What if I don't like these terms and don't agree to the OGL commercial? That's fine. It just means that you cannot earn income from any SRD-based D&D content you create on or after January 13th, 2023, and you will need to either operate under the new OGL non-commercial or strike a custom direct deal with Wizards of the Coast for your project. But if you want to publish SRD-based content on or after January 13th, 2023, and commercialize it, your only option is to agree to the OGL commercial. And yeah, can't wait to see them wrongly copyright claim videos. That's coming. That is coming. So, and I see here, I bring it up because this feels like a negotiation between Corp and Creators Fan. It's the kind of negotiation that happens at gunpoint, but you're not wrong. All right. Why is Wizards of the Coast updating OGL 1.1 and subdividing it into commercial and non-commercial terms? A lot has changed since the old OGL was launched, and that means the old license has some unintended applications we need to fix. Like, people are playing D&D, and they like D&D. They're going to fix that. They're going to fix it real hard. For example, when we released OGL 1.0a, YouTube, apps, blockchain, crowdfunding, and other now everyday technologies and distribution channels didn't really exist in the way they do today. And honestly, it's been doing just fine with all of these things. OGL wasn't intended to fund major competitors, and it doesn't fund them. It doesn't provide them with a single dollar. It allows them to create their own content. And it wasn't intended to allow people to make D&D apps, videos, or anything other than printed or printable materials for use while gaming. I call BS on this because it was absolutely intended to allow people to make things like online character creation systems. We're going to talk about why that's going to be something that they specifically want to deal with is, D&D apps, because that's something that that is on their radar. Videos. So like this channel, they don't like that. And I see here the 2004 OGL FAQs specifically said that software was allowable. Yeah. How would you say that it's not allowable when they specifically mentioned it? We are updating the OGL in part to make that very clear. You're updating the OGL because you are terrible. And that's not wrong there. Additionally, over time, the old OGL incorporated some confusing and even contradictory provisions. Name 2. It was also written in fairly dense legal language. Yeah, okay. Do you think 9,000 words undensed it? So while we're updating it to take into account developments since it was last reviewed and breaking out commercial use into a separate category, we're also simplifying the language and streamlining the provisions so that it's easier to understand and comply with. I don't know that easier to understand is exactly, exactly, what would apply here. I see Gremlin saying they will strike this stream. Good luck. And it's not fair use because you're making jokes to them and this entire document is already a joke. This is, legal analysis is pretty much the textbook example of, fair use, fair dealing. So good luck on that one. All right. For even more clarity, we've included comments that should help illustrate what the provisions do, which you can access by clicking the relevant comment links in the license documents. So those appear to be in here as well. So we strongly believe in the power of creativity and the goal of the old OGL, and this new OGL revision in both commercial and non-commercial form is helping our incredible community to build and share campaigns, supplements, and other content that enriches the way we play D&D. It is not doing that, and no, they don't. They believe in the power of, money. They believe that's what they believe in is currency, and they think that this is going to help. So we'll talk about that. All right. Who can I contact if I don't understand something or need help? If you have any questions about what you read in the OGL non-commercial or OGL commercial, please reach out to us at To Be Determined before using or signing either part of the license. The preceding material is not part of the OGL 1.1. To access the subdivision of the OGL 1.1 that applies to your use of the SRD content, click below. So what this means is that all of that stuff that we just read is an explanation, and it doesn't, this is not part of the legal text. This is just them, that's their PR. That's their legal buzzwords and so forth. All right. Any non-commercial use of licensed content defined below is subject to this agreement by using, so this is the non-commercial, the OGL non-commercial here. All right. Is subject to this agreement by using licensed content in this manner. You agree to the terms of this agreement. Now, this is interesting. They're basically trying to say that they are foisting this agreement on anybody who uses their licensed content. I don't know if that's necessarily, you can't really do that. It is still possible to just infringe or just to publish stuff under fair use, fair dealing. They can't extinguish fair use and fair dealing in the in the course of this. So that's kind of a critical aspect here. So I'm just noting here about some issue there. All right. Content covered, or sorry. This agreement contains your consent to jurisdiction in Washington state for any disputes between you and us, and your agreement that any such disputes will be resolved in individual litigation heard by a judge rather than jury. If a dispute ever occurs, we hope you agree with us that it's best all around if it's handled quickly, efficiently, and with the least expense possible. Note that when they say the least expense possible, they mean to them. They're actually going to be able to maximize expenses to you. So we'll have a look at those clauses because this is really more of a summary to that, and we'll have a look. So content covered and not Dungeons and Dragons involves several different categories of content created by the creator, the you, and by Wizards of the Coast. That's an interesting phrasing, the you, and its parents, affiliates, suppliers, and distributors, us or we. Here are the different kinds of content and how they relate to this license. So content covered, and they're going to have all sorts of things. I see a generic account is saying, too bad Hogue is busy, would love his take. Hogue is currently in recovery. He's had a stroke. We hope he gets better as soon as we can because, yeah. Now, we'll talk about the jurisdiction clause when we get there because, that's sort of a plain language summary. We'll look at the actual language on this. All right. So usable D&D content, licensed content. This is Dungeons & Dragons content that is included in the SRD 5.1, including basic game mechanics and a curated selection of classes, monsters, spells, and items that allow you to make content compatible with Dungeons & Dragons 5th edition. We're just going to throw a little highlight on that because this is important. This is really, really critical here. And I see Prototopics looking forward to talk to Rick about this one day. Absolutely. So we're going to have a look at this. All right. Not usable D&D content, unlicensed content. This is Dungeons & Dragons content that has been or later will be produced as official, that is released by Wizards of the Coast or any of its predecessors or successors, and is not present in the SRD 5.1. Unlicensed content includes things like the most famous Dungeons & Dragons monsters, characters, magic spells, and things relating to the various settings used in Dungeons & Dragons official content over the years, what the old open game license referred to as product identity. So specifically, they're talking about things like, Mordenkainen, beholders, that kind of stuff. Unlicensed content, although also anything that they put out in later books and so forth. So all of that. Unlicensed content is not covered by this agreement, and you agree not to use the unlicensed content unless your use is specifically authorized by a separate agreement with us. If you want to include that content in your work, you must go through the Dungeon Masters Guild or other official channels. Why do they want you to go through the Dungeon Masters Guild? Well, the Dungeon Masters Guild actually includes a whole lot of restrictions, including that you have to give them basically full rights to everything, including the option to just never pay you for it. So you'd basically be giving them the right to steal your stuff if they wanted. So your content, these are the characters, classes, settings, spells, items, new rules, and other creations that you have crafted. They are your original contributions to the works that you want to sell. This license permits you to combine your content with the licensed content and commercially distribute the resulting works. Okay. And I see Goliath Cleric saying there's nothing in this that stops them from making your third-party content into unlicensed content by republishing it themselves. In fact, they explicitly permit themselves to do that. So works covered. This license applies to materials you create for use in or as role-playing games and as game supplements, and only as printed media and static electronic files such as EPUBs or PDFs. It does not allow the distribution of any other form of media and does not apply to the creation of anything else. So they're going to be shutting down a whole lot of things. I'm seeing, can I put membership on? I will have to create membership options at some point and figure out how I'm going to do that. So, all right, comments. To be clear, OGL non-commercial only allows for creation of role-playing games and supplements in printed media and static electronic file formats. It does not allow for anything else, including but not limited to things like videos. Hey, we're doing a video right now. Virtual tabletops or virtual tabletop campaigns. They specifically call that out, right? Computer games, novels, apps, graphic novels, music, songs, dances, and pantomimes. You may engage in these activities only to the extent allowed under the Wizards of the Coast fan content policy or separately agreed between you and us. So they really absolutely are trying to shut down things like Foundry. Absolutely trying to they want to have it so that there's only one virtual tabletop allowed for Dungeons and Dragons, and it's their microtransaction hell, because the system that they're talking about is going to be heavily microtransaction based, and so they want to make sure that you have no other options. So that's an interesting aspect. The other thing is they talk about apps. And apps here, includes things like character creation stuff. And the reason why they want to cover that is because they want you to have to use their D&D Beyond system or their new virtual tabletop system. And, again, to push things to a system where it's their system. They want to push you to their specific thing here. And I see here, what is it? Roll20. Yes, they do want to target Roll20 as well. So that is, that's a big aspect here. They want to monopolize the digital RPG space. Yes. Now I see a lot of people asking this one. Why is pantomime included? Because they're being cute. That's what this is about. They're being cutesy here. So yeah, they're just throwing that in as, you know, sort of a cutesy deal there. So lots of people are trying to interpret this as something more than them thinking that they're, you know, this is kind of a how are you doing, fellow children kind of, you know, kind of moment. So that's what's going on there. So, and I see Roll20 has a license. Sure. For now. Will they always have a license, or will D&D Beyond say, hey, you know what? Or will Wizards of the Coast say, hey, you know what? We're canceling that license. We're not renewing that any further. So Roll20, shut yourselves down, or, you know, so that everyone can get on with moving over to our new, you know, our new system. See here, they wrote this to mock the player base, and they thought we would not understand that they're mocking us. I mean, they thought that people would be okay with this, and that this would be taken as a funny joke. But it's not. Like, we're not enjoying this. We're not. Yeah. All right. So licensed works. For a work to be a licensed work under this OGL non-commercial, it must meet all 4 of the following. So you've got to do certain things to fall under the license. 1, it qualifies as a covered works as defined in section 1B, which we covered. A, it contains both licensed content and your content, so you can't just put out something that is purely licensed content. B, it does not contain unlicensed content. And C, it contains the text of this OGL non-commercial within the body of the work. So you got to include the full text, and they're going to have an explanation of what they have there. I see pantomime includes cosplay. It would be very difficult to violate the to violate copyright with a cosplay here. Pantomime is just a joke. It's not intended to cover anything. I don't think they ever plan to sue or send a letter about pantomime. It's just them trying to be funny. And so lots of people are trying to figure out what that means. It's just them trying to be funny. So license. If and only if you comply with the terms and conditions of this agreement, you may copy, use, modify, and distribute licensed content around the world as part of licensed works on a non-commercial basis. And we'll talk about what that means here, meaning for free, not in exchange for money or any other thing of value. A, we may offer others the ability to use licensed content or unlicensed content under any conditions we choose. So this is basically saying, hey, listen, we can go ahead and we can, you know, offer other people better deals than this. So, yeah, and I see they can't shut down Roll20 as a general virtual tabletop, but they can force them to not support games covered by the new OGL. Yeah, that's exactly it. They want to make this specifically for the D&D can only really be played on their virtual tabletop. I see. So is this a legit document? When I read it, it didn't seem like it was real. It's been confirmed by multiple sources. It looks like a legit document to me. I think it would be a hell of an effort for a prank on that one. So, yeah, it looks legit. I believe that this is an accurate document. B, you may not transfer your rights and duties under this agreement under any circumstance or for any reason. This license is not sublicensable, which is interesting because it means that if your company, you know, wants to sell its assets to someone else, then yeah. I see pantomime equals TikTok. No, pantomime is just intended as a joke. Pantomime is a stage performance. They're not actually expecting anyone to do pantomimes. TikTok would be covered under video content. So lots of people are trying to make big noise about pantomime. Pantomime is them trying to be funny. So don't try to interpret it as meaning anything other than pantomime. It's, yeah. All right. And I see if this document was a prank, Wizards of the Coast would have quickly come out and denied it. The fact they didn't is telling. Yes, absolutely. I've said that before, is that if this was fake, Wizards of the Coast would have come out in a hot second to say, listen, this is not accurate. And they haven't done that. I see never assume that people writing contracts are joking, but we can actually infer, like we can read humor, right? And I mean, I did a giveaway for a knife a while back, and that mentioned that I specifically disclaimed acts of ninjas. It's not because I expected ninjas, it's because ninjas are funny. So yeah. And I put, yeah, didn't they have something about the Demogorgon coming after you in another part? They've had lots of things about that. So yeah. All right. How to say you don't live in the UK without saying you don't live in the UK. Try and say what pantomime is incorrectly. I mean, lots of people want to make pantomime as a thing here, and it's really the least important thing. So, all right. Comments. As we said in the intro, commercial distribution. Now, these comments are actually part of the contract. This is written in, sort of some natural language here. Commercial distribution is any distribution you get paid for in any form. Now, you might be wondering, why is it capitalized? It's because they defined you earlier. So this is a defined term. You get paid for in any form: money, crypto, barter, your brother doing your chores for a week, whatever. It does not include donations people give you to support your work, as long as they can have access to your work for free if they choose to, and you inform them of that in a clear and obvious way. Now, so what this is intended to cover is anything with a paywall. So if you've got, some, if you do video content, but some of it is locked behind members only streams, this would cover that. If you do Patreon content and you have some stuff that is explicitly only for Patreon supporters, which is pretty much the usual model of Patreon, then this would, say that you are in commercial distribution. If you do, anything like that. Now, there are some really interesting places where I think that this is unexplained. For instance, let's, this video, after it's live, will go up and be a video that you can watch later. And so if you watch this video later, there's going to be ads on it, because that's just how YouTube works. And I get paid a tiny piece of those ads. I can tell you that from one of my previous videos, I made 70 whole cents. 70 cents. But people do still have to access that through those ad content, and I get like a tiny cut of that. So is that commercial distribution because you have to see those ads in order to, in order to get it? Maybe. They didn't make that super clear. Another thing that happens is you can see that there's the Patreon model where you go and, you put content up that is is behind a sort of paywall. But there's another crowdfunding model, and that is something that goes like, basically, hey, listen, my works are always free. Everything I make is free. However, I will only make another work once the amount I've earned from the first work hits, say 10 grand. So I say, basically, once I have 10 grand in support, I'm going to start work on, volume 2. And volume 2 will be then available for free once that, is out. So it's not clear whether that would be covered as, as a commercial use or not. So, and I see the model they suggest would kill crowdfunding, basically. And also, Prototopics. Do you have to pay Wizards of the Coast anything as a pro DM? Well, that's going to get interesting. They might try that. So we'll have to see on that as well. All right. Look here as we go. So ownership. You agree that we own copyright, trademark, and patent rights, if any, in the licensed content and the unlicensed content. We reserve all rights not expressly given to you through this agreement. You agree to include any copyright or other notices, including with the licensed content in your licensed works, and you may not impose any additional, different, or inconsistent terms or conditions with respect to licensed content in any license you grant to any licensed works. All right, so that is complicated. And I see, is streams of gameplay mentioned anywhere? No, but this is going to fall into a great big murky hole as to whether or not that's allowable. All right, so identification of licensed content. You must identify in your licensed work which content is licensed content and which content is your content in a way that allows the reader of your licensed work to understand the distinction without checking any other document. This is going to be something that takes a tremendous amount of work for people. And so, yes. And I see, would this mean that they could use art that you've paid for in your product? Yes, it absolutely would. So, yeah. All right. Comments. You can identify content in any manner you want to, whether that's using a different font for licensed content than for your content. Can you imagine how obnoxious that would be to read? You're trying to read over a D&D book, and then suddenly it jumps to a different font because it's included licensed content. Or putting an asterisk next to licensed content and telling readers what those distinctions mean. Citing to the SRD whenever you use licensed content. Dragonborn, SRD page 5. Or putting a separate index or link in her list in the back of your licensed work that lists out what exactly you used from the SRD or something else we haven't thought of, but you did. How you do that, the capitalization of you, because they're using it as a defined term, is really, really obnoxious here. Or how you do that is entirely up to you. If your readers can't tell what's what, or can tell what's what, we're satisfied. But it is not enough to simply include a statement that your licensed work includes licensed content, what used to be called open game content, if the only way a reader can distinguish what you created is from what we did is to check your licensed work against the SRD. You are not in compliance with this provision. So this is a big change because prior to this, you could just go ahead and say, hey, we've got some SRD content. And the reason why this is important is because people were using the OGL as kind of a defensive measure. They were saying, listen, we don't think anything here is something that Wizards can sue us over, but we're going to just put it out under the OGL because that way we can try to get this, try to ensure that we're protected. And it looks like we've got spam bots. That is kind of a good sign because it indicates we've got a lot more interest than I expected on this one. I am just flicking on subscribers only mode so that we don't have to see the spam bots. Sorry, folks. All right. So now they're basically saying you have to explicitly cite what you think is there, which is actually going to be a lot of work because you have to go through and like decide, hey, is this SRD content? And, so forth. It's going to make it unreadable in a lot of cases because if the fonts are jumping back and forth, that's going to be miserable. But yeah, I think that this is really going to be a headache for a lot of people there. All right. And it's going to mean that a lot of places are thrown into legal limbo because, for instance, there was a lot of places that say, hey, we've got strength, dexterity, constitution, which I don't think in and of itself is necessarily copyrightable or covered by that. But again, I could be wrong. This is an interesting question, and it could be a very expensive question. But yeah. So we're going to see a lot more people thrown into very difficult scenarios there. And that's going to make it very hard for a lot of these other games to exist. All right. I see. Is forcing people to give Wizards of the Coast rights to use their created stuff legal? Unfortunately, probably. Yeah. So, all right. This is actually a nasty clause here. Share alike. We're letting you use licensed content for free because you're using it on a non-commercial basis. If you want to better protect your ownership, you may register under the OGL commercial. You agree that others can do the same with your work. So this is kind of a Creative Commons license in the worst form of Creative Commons, because it's Creative Commons in a sense that is used maliciously to actually, like, Creative Commons to actually push people to a license that benefits wizards. So yeah, and I see, thank you for Jessica Michelle, and I see Runkle is exaggerating. He reads legal documents all the time, and that's full of italicized text. Everyone wants to read like stuff like that in their free time, don't they? I don't even enjoy reading those kinds of documents. So like when you're having to read something that's a red line version where they've had to specifically identify all the stuff that they've changed, I mean, it's useful, but it's miserable. And making people do redlining to publish material is a tremendous amount of work. And yeah. So if you enjoy this stream and want more of the same, hit the gavel on the like. Yes, hit that like button. It is really helpful for the YouTube algorithms. So please do that if you can. If not, that's fine too. All right. So each time you distribute or otherwise make your work available, you offer the recipients a license to the work on the same terms and conditions granted under this license. You may not impose upon others any terms that alter, restrict, or otherwise change the terms of this license, or the recipients exercise the rights granted under this license. So you can't add any terms, which is actually a fairly big restriction, because you might have wanted to add things saying, you know, this can be distributed in this way, but not this other. So I see. Imagine those poor unfortunates with Kickstarters ready to launch. Yep, that would be hugely bad right now. Lord God, what if you publish content licensed by you, not owned by you, permitted by a creator for your book, perhaps, but not permitted for reproduction? Then you cannot use the non-commercial license. So you simply could not do that, which kills any non-commercial work that includes artwork, for instance. It includes any non-commercial work that includes anything that you had to license from someone else, because you probably don't have the terms to include that or to sub-license those documents in that fashion. So, all right. You must distribute a copy of this license alongside your work. For clarity, the license should probably appear at either the front or the back of the book, but it must be in the book. So that means that you can't have it as like a set. They don't want you having it as like a separate, document where you distribute your book as like a zip file with like a README. They don't want that. All right. The version of the license you enclose with your work must be this license. You must keep intact all notices that refer to it, and you must keep its disclaimer of warranties. Okay, that's not a hugely nasty clause, but fair enough. Donations. Now, keep in mind, this thing is many pages long. So if you're, it's 15 pages on this, I expect it'll actually be a little bit longer when it comes out, because there's going to be formatting. There's going to be other things. They might shrink the font down to make it less, but it'll still be nasty. So if you're publishing a 2-page document and then you have to stick on 15 pages of BS, people are going to be annoyed, because they're going to be like, hey, I'm buying a 17-page document, 17 pages of new spells, except it's actually only 2 pages. People are going to think you're ripping them off. All right. Donations. So they specifically have something about donations. Your distribution of your work must be non-commercial. This means that you cannot require that anyone give you anything of value in exchange for your work or copies of your work. However, you are permitted to accept donations through Patreon, Ko-fi, or any other similar platforms, provided that the donations are not a condition of the receipt of your work, and you make that clear and obvious to your donors. In other words, if you make your work available for free and ask others to contribute what they like so that you can continue to do so, you're fine. But if any of your work is available only to subscribers, patrons, or any other word for people who give you money for access to it, then your non-free work is subject to the OGL commercial, and all of that income is revenue under that license. So, yeah, this is a big deal here in terms of Patreon supporters. And one thing that isn't clear. So let's say I've got, you know, three different terms of, you know, three different types of patrons. And for instance, let's say that I give people access 2 weeks early to stuff about my, like, let's say I'm doing a campaign and that I give patrons access 2 weeks earlier than regular people to stuff that goes up on that. That's a pretty common, you know, model there. Does that breach this donations clause, or am I good? Because everybody will eventually get access. Now you might say, hey, that sounds like it's reasonable. I can see that Wizards would absolutely argue that it wasn't, because, for instance, let's say instead I set up a patron and I say, you know what, all of my content is going to be available for free to anyone in 10 years. So you get a 10, you know, then they'd be like, well, that's not really. So this is really unclear here as to what this means. And they didn't think about that. And Wizards, if you're watching, don't fix this to like tighten up these problems here. Fix it to unscrew the document. And I'll talk a little bit about what unscrewing the document would look like. Donna Parker, thank you very much for the very generous super sticker. And I see, could Paizo just rename everything and get around the OGL completely? Did your Cobalt Press is saying, said they will be creating their own tabletop role-playing game? Lots of people are going to be trying to create their own tabletop game. I am getting tempted to do so as well, and to put it out under a license that allows for broad use. So for, you know, any of that. I'm thinking about the conventions that sometimes have one-off RPGs, sometimes LARP tabletop. Technically, the convention is an admission cost, so while the game itself is free, access to it isn't. Yeah, what happens if I go to a convention and say, hey, here's new content that's available? Is that a breach? So further thought, you know, they've said for the creative, you know, for the commercial stuff. So let's say I have a patron and I have two tiers. Tier 1 is $1. It's just support me because you want to support me. And tier 2 is $40 and, you know, per month. And that says you get access to all this cool stuff and I limit it. Do I have to pay them on the $40 only, or do I also have to pay them on the $1 patrons? Because the $1 might actually be the bigger thing there. All right. So this, as I mentioned, is going to destroy a lot of people who are currently operating in the sphere, a ton of people. And, you know, there's a lot of YouTube content creators who this will absolutely ruin. Quite frankly, there's content out there by big names that this would cause all sorts of problems for. So this will be a huge, huge impact on the third-party market there. It is... it's brutal. All right. Warranties and disclaimers. You represent and warrant that. So these are basically things you promise to Wizards of the Coast when you sign up here. So A, you are over 18 years of age, or if younger, have had your parent or guardian review these terms and agree to them on your behalf. That's because kids are limited as to how they can be involved in contracts. B, you have the power, the authority, and the right to enter into this agreement and perform the obligations it asks of you. So you can actually form a contract is basically what they're saying here. And I see that one I'm going to star because I'll come back to it. If we require additional paperwork or documentation from you in connection with the license work, you will provide it to us as soon as possible. This is a scary clause. I don't know what this means. What additional paperwork or documentation? Like, hey, do you want my driver's license? Do you want my tax returns? Do you what are they going to be asking for? This is not clear. So that's worrying. So you will comply with any other requirements we have related to this document, such as registering or creating an account with us. Now, this is a really interesting aspect because they say you have to create this account. Well, if you have to create an account with them, that basically means that this open game license is in fact not open at all, because you can, and that one I'm going to star as well, because they can block you from creating an account. So, they can, if they ban you from this account system that is necessary for being covered under this open game license, then they really get to pick and choose as to, who gets to make content, which is kind of terrifying. And I see Jacoby Davis, can you point people to the Open D&D? I can't Google it right now because I'm in the middle of a stream, but if somebody posts it up, I will try to throw it up in the or pin it in the chat here. So it's presently being sued by VTT makers and third-party content, or signed by virtual tabletop makers and third-party content makers alike. Yes, I've signed it as well. So we'll just look here. I see this thing is worse than the 4th edition GSL. It is absolutely worse. So absolutely. And Greg Gillespie makes an excellent point. Wizards of the Coast isn't going to bother with litigation. They will attack and deplatform instead. What they will do what I expect they'll do is they'll run 1 or 2 lawsuits against what they think are soft targets to try to generate some. I mean, this is what I would do if I was working for Wizards of the Coast and was evil. And I mean, I think that the two things kind of go together. But I mean, whoever wrote this wrote a document that is kind of evil. So what they'll do, or what I would do if I was in their situation is, and I wanted to be as evil as possible, which they seem to do, is I would go after 1 or 2 soft targets, people who I didn't think could defend themselves very well and whose cases were sort of on the more egregious levels of things. I would pick somebody who generates content that is obnoxious or, objectionable in some way, so that there'd be minimal sympathy. And so, and get some favorable case law as a result of that. Once you have that, you turn around and you go to all the platforms where you might post stuff for sale, like say Patreon and so forth, and then say, hey, listen, you need to take this down because this is copyrighted works, and, start DMCAing stuff and stuff like that. So that is what I expect. I expect we'll see a lot of DMCA notifications and, people getting their stuff taken down, so that people's Patreons just go away. So, yeah. See, now all the articles on how to play an evil character make sense. Yes, this is lawful evil. If, if you're doing an alignment chart, you could just put the OGL 1.1 on as lawful evil. Yeah, and I see, or something like Drive-Through RPG, attempting to stop the sale of all unlicensed content. They'll probably go through Drive-Through RPG and just be like, we are DMCAing 3/4 of your catalog. Bye. So, and then if they can shut Drive-Through RPG down because all of those lost sales and so forth, then, hey, guess where you have to go? Oh, right. The DM's Guild. Yeah. All right. Your licensed work do not and will not infringe upon any third party's intellectual property rights or any of our rights not licensed to you via this agreement or any other. So can't be based on copyright infringement. All right. You will not state, suggest, or imply that your licensed works are endorsed by or associated with us, except that you must include the text of this OGL non-commercial within the body of the work to indicate that your licensed works are compliant with this agreement. I can explicitly state that this channel is not endorsed by Wizards of the Coast or associated with the Wizards of the Coast, and that Wizards of the Coast can go to heck. All right. Michael Robertson, this is a good question. We'll come back to it. So, yeah. You will not violate the law in any way relating to this agreement or your licensed works. Not sure what they were thinking of here, but okay, not violating the law, cool. You will not use any of the content or works covered by Section 1 for any harmful, discriminatory, illegal, obscene, or harassing purposes. We're going to come back to this because there's other clauses that talk about this. So, yeah. You will not do anything that could harm our reputation, that of Dungeons and Dragons, or the reputation of the licensed content or unlicensed content. For purposes of clarity, this provision does not apply to criticism of Wizards of the Coast, Dungeons and Dragons, or the licensed content or unlicensed content that does not independently violate these provisions. Okay, this one is hilarious because you will not do anything that could harm our reputation. Like, say, writing this document. The biggest harm to Wizards of the Coast's reputation that has happened in recent times is right here, right now, this document. So yeah, you don't want me to put out anything that harms your reputation. Maybe you guys should not do that to yourselves. Like, come on, guys. Think a little bit harder about what you're doing here. All right, so I'm just seeing that Secret has found the link there. I'm just going to sticky that, or pin that, so that should be pinned. All right. So you will not attempt to circumvent or go around this agreement in any way. So there are times when an anti-circumvention provision makes sense, but I don't think this is one of them. And they certainly, at this stage, for the non-commercial aspect, can't really think of a way that this would be applied. There's no examples here. So I don't know what this would even look like, but they've included this clause. So yeah. Termination. This agreement may be modified or terminated. So this is, interesting. Modification. This agreement is, along with the OGL commercial, an update to the previously available OGL 1.0 sub A, which is no longer an authorized license agreement. So the previous OGL specified that you could publish things under any authorized agreement. And now they're saying it's no longer an authorized agreement. So this is an explicit and specific attempt to revoke the OGL 1.0. So lots of people are asking, can they do that? And the answer to that is a big maybe. Contracts go towards the intent of the parties, as in what did people intend? And there is evidence out there that they intended an irrevocable contract, but they didn't actually say irrevocable contract in the language, which means that there's a presumption that it's revocable. What does this mean? It means we're into interesting legal questions, and interesting means expensive. My estimate that I've been thrown out is $500,000 to throw at litigation on this. And that might be an underestimate. So they're saying that they revoke that OGL. What they're also saying is that they revoke any agreement for any previous version as well. So specifically, they're saying here that this is the only document, and that in fact you cannot make content for previous versions anymore. So that you could not use content for, even under 4E's GSL or 3.5's OGL. They're saying that those documents no longer are authorized. So that is also terrifying in and of itself, right? So, yeah. All right. Now I see here John M saying, if you created under another system and made a free document with items, spells, monsters, NPCs converted to D&D, would they still have a valid vector of attack? Lawyer answer, it depends. Could they still take your IP and reprint? Only if you put it under this license. But if you put it under this license, then they absolutely can. So, yes. All right, termination. We may terminate the agreement immediately if. So this is stuff that allows them to just cancel it right away just because. And I see that's the wrong petition. It's at Open D&D Games with a period between D&D and games. I wish I could post the link myself, but obviously rules exist. Secret McSquirrel, see if you can find that other one. Thank you. I see, how much legal weight would Ryan Dancy, one of the original architects of OGL 1.0, on legal questions the original intent of OGL 1.0? Some. I would certainly call him as a witness, 100%. But we'll have to see sort of what we're looking at there. All right. So A, these are clauses, again, that allow them to cancel your use of the OGL which then basically means you have to stop publishing your work. So you infringe upon or misuse any of our intellectual property, violate any law in relation to your activities under this agreement, or if we determine in our sole discretion that you have violated sections V3 sub G or sub H. To be clear, we have the sole right to decide what conduct violates those two sections, and you covenant and agree that you will not contest any such determination via any suit or other legal action. To the extent necessary and allowed by law, you waive any duty of good faith and fair dealing we would otherwise have in making any such determination. So, and when we look at G and H, where are those here? So G is you shall not or will not violate the law in any way relating to this agreement or your licensed work. Or H, you will not use any of the content or works for any harmful, discriminatory, illegal, obscene, or harassing purposes. Now, they've said that they have the right, they're giving themselves the right to make the sole determination here and that you can't challenge their decision in any way. So, what does that mean? Let's say you make an OGL work and it is, cute kittens and daisies. And all it's about is about the adventures of cute kittens and daisies. And it is as inoffensive as could possibly be. And, inoffensive and lighthearted, and nobody could ever, well, they can say, you know what? We think that's racist. Your cute kittens document is racist. We are terminating your agreement. And it doesn't have to make sense. It doesn't have to be reasonable. It doesn't have to anything. They can just decide that. Now, this is when it's worth talking about a little bit of, Dungeons and Dragons' own works. You guys remember the how does the kerfuffle on that one? They put out the Spelljammer book, and the Spelljammer book included a race of basically monkey people who escaped from slavery. And people went, "Hey, wizards, what the actual F is with this?" And wizards went, "Whoa, we didn't mean for this to be racist. We're going to backpedal." And they blamed the original source, although the whole slavery thing wasn't in the original stuff. It was just that they were kind of spider monkey people and, which made them really good at climbing ship rigging and that kind of thing. So, yeah, it's entirely possible for a game designer to inadvertently create something that they end up deciding is, falls under this because they've done it themselves and they had to backpedal on that. So yeah. And I see, let me remind you that Wizards cut a lot of Magic the Gathering cards and a lot of D&D stuff because of racism issues. Yeah. So that's going to be interesting, right? So, and I see as well somebody noting here, in D&D, most races are also racist against tieflings. So does that qualify as racism? Well, in one D&D, no race is racist against another. Everybody likes everybody. So tieflings are not judged for being tieflings. Nobody judges anybody for, which, okay, it's kind of a nice world, but most people are playing in worlds that are a little darker than that. So, and in fact, a lot of people play tieflings currently because they want to explore those ideas. In fact, I've seen surveys of trans gamers, and one of the things that's kind of surprising is just how many trans gamers like tieflings, because it allows them to explore these ideas of like overcoming, these judgments and so forth in a safe and fairly inoffensive kind of way. It's a way to sort of get the feelings of heroism about some of the discrimination that you might experience in life in a way that feels safer, right? So yeah. I see there's a lot of people here. Don't forget to do the YouTube things. You know what that means, Runkle. It won't let me subscribe or super chat to like and subscribe. That's weird. But yes. So so do those things, like and subscribe. But yeah. In Spelljammer, almost every race was enslaved at some point. Yes, because mind flayers are a big deal in Spelljammer, and I mean that's kind of their MO, is enslaving other races and other species. Because yeah. All right, so let's keep going. Or if you breach any other term or condition in this agreement, and that breach is not cured within 30 days of our providing you notice of the breach by communicating with you as provided in section 3 sub A. We'll talk about their notice provisions. And it looks like we've got a different thing here. I'm just going to replace the pinned message. There we go. And over Goddess, I will get to that as we go. So, do you feel as though offensive content may circumvent this by having a different expression of the mechanics? I got rather spooked that bigoted content may be on the rise due to this. I mean, that's one way people might do it. Yeah, it'll be interesting. And I see Honk Banana No. So one D&D is aimed at stories without conflict then, like everybody has that one illithid friend who bakes the best muffins. I mean, the problem is that when you get into, like, when you eliminate all of this and, like, say there's no evil races, like there's no inherently evil races, then it's like, well, now we're into this interesting aspect of me going and, killing my way through a dungeon becomes a moral quandary. Like, hey, shouldn't I be trying to reform these orcs and teach them, like set up, instead of killing my way through this dungeon, why aren't I setting up an orc soup kitchen to, because ordinary morality typically limits when you can go on murder sprees. And, so this actually makes things in some ways a lot worse. Because yeah, I've got some concerns over this and sort of what it means for gaming. Because the one thing I really hate and I'm just tired of is you see it all the time, and somebody just mentioned it in the chat here. The orc babies scenario, where it's like, oh, well, are they going to grow up? Because DMs throw this in, and it's basically a way to derail the game with arguments over morality for the next 2 hours. And sometimes that's not what you're there for. You just want to, have a beer and some popcorn and, so forth with your friends. So not everything needs to be complex morality. And yeah, I see they're not bound to be orcs. They could just as easily be humans or elves or halflings in the dungeon. That's one change I actually like. You could always put humans or halflings or elves in the dungeon. I mean, yeah. So I personally like games that don't have defined evil races, but also sometimes I just want to murder way through a dungeon without worrying about morality. I mean, my campaign setting has some of both. There's, races that are, that may lean towards being antagonists because of cultural elements and so forth. And there are also just, people who are straight up evil because there's something akin to the, like, concept of demonic evil, in the sense of, like, irredeemably. And yeah, so all right. So yeah, all right. You bring an action challenging our ownership of the licensed content, unlicensed content, or any patent or trademark owned by Wizards of the Coast. This is interesting because if you sue them over, a dispute over what is covered or not, then at that point, you immediately can have all of your non-commercial work taken off the internet. So that's interesting. Basically, don't sue us or else is what this comes to. And you can terminate this at any time by 1, ceasing all distribution of your licensed work, and 2, providing us with written notice. So you can cancel this by just dropping off the internet entirely. All right. So, and I see I made elves evil. Oh, that's first edition drought. Never mind. In my campaign setting, there are. So one of the things I explore is that an evil deity of treachery and deception created basically fake elves, and they look exactly like regular elves. 100%. They're super, super difficult to determine, even using magic, because they can choose the results of a whole bunch of different magical spells and effects. And so, if you cast something to determine their alignment, they know that you've cast it, and they can say, yeah, I feel like it should come back as chaotic good. That is just one of their powers. They also can recognize each other on site, which allows them to plan because they just show up and can say, hey, yep. And I see somebody saying they're replicants then. Pretty much. However, so like the dark elves in the setting aren't like the drow dark-skinned elves are evil, BS. It's just there are evil elves that look exactly like every other elf. And yet they're like psycho murder machines that will smile at you and pretend that they're friendly. So this results in a massive culture shift because elves then have to deal with the fact that they've been thrown into a perpetual game of Werewolves of Miller Hollow on high stakes. So they are perpetually having. And so what does this do to their culture? What does this do to their society? Well, elves now have to have a tradition of basically you come in and you bring receipts. When you introduce yourself to other elves, as an elf, your introduction is going to be essentially a resume. You're going to be talking about where you've been and what you've been doing in ways that allow them to check up on you so that they can go and say, yeah, this guy's legit. Because elves have long lifespans. And so therefore you've got this whole thing of, ideally you should be an elf with receipts as to where you've been and that you've not been out there being a massive, murder psychopath. So that is an important thing in elven culture. But it also affects how elves relate to other cultures, because other cultures maybe don't, have the same tradition of like the backstory. They just distrust elves really badly. So, it's like, okay, sure, most of you aren't going to murder us all, but we don't know if you're. So this creates some interesting tension that's not based on any real world kind of, racial animus, because there is no real world scenario that is analogous to this. Would they say, hey, listen, we think that that's discriminatory and your setting has to stop existing? I don't know. Maybe. I see. Wow, this elf tangent is going on a lot longer than I thought it would. Yes, it is. So we're going to carry on. What's the point of terminating the license with them if they still claim irrevocable rights to your stuff? If they terminate the license with you, because this is exactly what I was just going to get to, that the rest of it, them having the right to your stuff, persists. That's noted as being irrevocable. So they're just terminating your ability to use your stuff, but it doesn't terminate their ability to use your stuff. So them terminating the license with you is basically them going, this is ours now. The only people who can publish this is us. So at that point, they have basically kept your work, and they can decide to either publish it or not publish it, whether for profit or not, and not pay you a single dime based on all of that. So why would they want to terminate it? Because they get all of the benefits and none of the costs if they do. All right. So comments. We know this may come off as strong, but this is important. If you attempt to use the OGL as a basis to blatantly release racist, sexist, homophobic, transphobic, bigoted, or otherwise discriminatory content, or do anything we think triggers these provisions, your content is no longer licensed. Now, that's in their sole discretion. And again, they could decide that every single piece of content is bigoted tomorrow. And they don't need a reason. Like, they don't need a good reason. They can just do that because. So, it could be that your content is actually racist, or it could be that you are being very successful and they'd rather just steal your stuff. So, yeah. To be clear, we want to and will always support creators who are using the OGL to help them explore sensitive subjects in a positive manner. How can anyone rely on that? Like, how can anyone rely on this promise if they can just, terminate it if you do, right? I might think I'm exploring it in a positive manner. And in fact, I might be running a game with, like several people who would be affected, and we could all be thinking that we're exploring this in a fashion that is respectful, is open, is positive. But Wizards of the Coast could go, nah, canceled. So they're giving themselves the right to just kill your content for any reason or no reason. But we will not tolerate materials we consider to be in any way counter to the spirit of D&D. And yet you wrote 9,000 words on that. Like, this is counter to the spirit of D&D. And yeah, this is so ridiculous. Anyway, additionally, you waive any right to sue over our decision on these issues. We're aware of that. If we somehow stretch our decision of what is or is not objectionable under these clauses too far, we will receive community pushback and bad PR, which we'll ignore. We won't care about that. And frankly, if you try to wage a PR campaign, they've got a budget for PR that exceeds yours, and they will try to make you look like a terrible person. They will publish stuff basically saying, yeah, we took down his material because this person is a racist and a bigot. And then they'll put that out as statements. And then good luck getting hired when somebody Googles your name. So, yeah. All right. So we'll receive community pushback and bad PR, and we're more than open to being convinced that we made a wrong decision. But nobody gets to use the threat of a lawsuit as part of an attempt to convince us. This is what lawsuits are about, is about when you've been wronged. So them saying you're giving up your right, like, they don't have to remove your content because it's actually racist. They can just call it racist, and you are waiving your right to even good faith treatment. So they can explicitly say, nah, we don't even actually think it's racist. We're just calling it racist to counter this because we hate this guy and, he's making too much money. So, yeah, this is absolutely an insane clause. And, yeah. So termination. Upon termination of this agreement by Wizards of the Coast, you will cease all sales and distribution of your licensed works. And that's whether for free or, pay or anything else. Your obligation to pay royalties survives the termination of the agreement. So do the following provisions: Section 3, Section 7, and Sections 9 through 11. So even if they cancel this, there are provisions that carry forward. So we should look at 3 and 7. 7 is the warranties and disclaimers section. Section 3 is the ownership section, that you agree that they own everything. And sections 10 through 11, so is indemnity. We'll get to that. Other products, which is, we'll talk about that one, and the disclaimer of warranties. All right. So even if they kill the agreement, those things still persist. And we're going to talk about this as we go. Indemnity. And this is one that survives the clause here. If you get in legal trouble or get us in legal trouble, here's what will happen. So A, if we are on the receiving end of any legal claims, fees or expenses or penalties related to your licensed works, you're responsible for paying all of our costs, including attorney's fees, costs of court, and any judgments or settlements. So if they get sued, you're on the hook. That sucks, right? Because remember that $500,000? You don't even get to choose whether or not you're going to play that game, so long as you are under the OGL. So if you don't have tremendous money ready to go, they could absolutely come after you here. If a claim is raised against you in connection with a licensed work and you aren't defending such a claim to our satisfaction, we have the right, but not the obligation, to take over the defense of that claim against you. If we do so, you will reimburse us for our costs and expenses related to that defense. So, guys, let's look at what this means. So, let's say somebody decides to sue you, and the suit is for relatively small amounts, right? Let's say somebody decides to sue you for $5,000. $5,000. Now, you might think that's a lot of money. I don't have $5,000 ready to go, but it's still cheaper than running a lawsuit through, because so this is sort of in the nuisance claim amount, and often you'd probably just pay this amount out, rather than going through full litigation, because litigation might be that $500,000. So Wizards of the Coast says, no, we have the right to decide that you're going to fight this lawsuit, this $5,000 lawsuit, and you're going to fight it, and you're going to spend millions of dollars potentially fighting this lawsuit out. And you're going to, you personally, even though you didn't want to fight the lawsuit, have allowed them to decide that it's going to be fought at your expense. So they can say, that $5,000 claim, you're going to spend $500,000 defending that. And then you might still lose and have to pay the $5,000 on top of that $500,000. So be very wary about this clause, right? This allows them to make decisions for you that are not in your interest and that might cost you hojillions of dollars. Yeah. We may, at our discretion, seek to intervene in a case brought against you in order to join the defense of the claims while leaving you and your own counsel in charge of your defense. If we do so, we will defend at our own expense and cost. Wow, this is the first time when Wizards actually says they're going to pay their own bills. So I guess that's nice. As for our IP, that's ours to defend, and you don't have any obligation to defend Dungeons & Dragons IP yourself, and in fact wouldn't have the standing or legal right to do so. But they might certainly say that it is your problem and push these things on you. All right. Now, I see... the more I understand the document, the more I feel it's a 4chan troll. No, the more they are basically writing a document that is 100% in their favor and absolutely terrible for the average person who might want to use it. So, other products. Sometimes great minds think alike. We can't and won't cancel products out of fear they'd be seen as similar to licensed works. So, here is... if we are charitable to Wizards of the Coast, and I'm not inclined to be charitable to them because everything else in this document is awful, but there is a reason why you might include these kinds of things. And that is that lots of people have the same ideas. So, and this is very common that movies get sued over, hey, we sent you a script and you didn't run it, but then later you made this movie that uses elements from that script. Surely you must have copied us. So this is that is what this would be for. However, I don't trust them at all, and they've given themselves all sorts of rights that would allow them to do really nasty, scary things to you here. So let's talk about that. So you agree that nothing prohibits us from developing, distributing, or selling or promoting something that is substantially similar to a licensed work. B, you own the new and original content you create, but you agree to give us a non-exclusive. Non-exclusive is important here. It means that you can still use your content. It's not that you're licensing it exclusively, that only them can use it. You can theoretically license it to other people. Perpetual means that it's forever. Irrevocable means that it can't be canceled. And keep in mind, they have said that this clause survives termination of the agreement. So even if they say your content is racist and you're not allowed to use it anymore, they're saying they're allowed to use it. So, worldwide, sub-licensable, royalty-free license to use that content for any purpose. So we can do anything at all that we want with your content, and we don't have to pay you. You don't get to say no. And we can use it for content you might find objectionable. So, hey, we can use this for, racist content if they wanted. So, yeah. And I see here them saying, that it might be considered immoral in certain places. It's possible. We'll have to see. But I mean, all of that requires litigation, which is super expensive. For clarity, nothing contained in this section impacts your agreement that our licensed content, unlicensed content, and anything else you are not otherwise expressly authorized to use under the terms of this agreement or any other agreement remains our sole property. So we're not giving you anything, we're licensing it. So, disclaimer of warranties. You understand and agree that we are providing the permitted content as is and make no representation or warranty of any kind concerning your use of the permitted content, except as expressly stated in this agreement. We disclaim all warranties, express, implied, statutory, or otherwise. You bear all risk of using the permitted content, and such use is solely at your own discretion and risk. All right, so they get to, note that, and limitation of liability. We have no liability to you for any types of damages in connection with your use of the licensed content, including without limitation any indirect, consequential, special, punitive, or exemplary damages, so long as our conduct at issue was not grossly negligent or intentional. The grossly negligent or intentional is in there because that's lawyer language. I suspect that they're required to include that, and in fact, they'll go ahead and say that they are. And that's just limitations on what kinds of things you can disclaim. Comments. We're giving you a license, not agreeing to take on potential liability when we do so. To be honest, we're not really sure what we could do while making Dungeons & Dragons content available to you that could ever be grossly negligent, but our lawyers say we need to include that last clause under Washington law, so in it goes. I suspect that is because they need to have that in there in order for that waiver to be sort of acceptable. I note here, Wizards of the Coast has taken lessons on how to screw their community from Games Workshop. They have said that this is the D&D is under monetized. So, yeah. See, I've seen lawyers from the UK, Australia, and the US, EU say it probably won't. Plus, the loser of a case bears the cost. So, Wizards of the Coast nuclear lawfare tactics won't work either. You typically have to pay those costs ahead of time, though. And often the loser pays costs is not full costs. It's often only a portion. Canada is a loser pays cost jurisdiction, and I can tell you it is still entirely possible that you get nuked by a lawsuit in that fashion. So, all right, notices, miscellaneous. Notices. Any notices you sent us must be sent to us via email too. That's a typo. That's just drafting problems. We may send notices to you to any email or physical address we can locate for you, including the email address used for your registration with D&D Beyond if you registered an account on that platform. So literally, they can just send an email to something they think is your email address, and they have no obligation to make sure that it's one that you currently use or that you received it or whatever. This is really interesting. Because, I mean, I've got email addresses floating around for me in weird corners of the internet that I haven't used in decades. They're not in use. So, yeah. Washington law requires both parties to execute a contract in good faith. Does that affect the reading of any of this? They disclaim all of that. So, yeah. And I see... your work email address? Possibly. Yep. They could certainly send that. I see there's plenty of good in this agreement, but all the blank spots, mind you, but still, yeah, I mean, the thing is that there are portions that, like, say you've got permission to do this stuff. The problem is that the negative aspects say that you would be crazy to actually do it. So I'm certainly not going to be doing OGL content under these terms here. Entire agreement and disclaimer of reliance. This agreement covers your use of the licensed content, and unless otherwise stated in this agreement, any prior agreements between us and you are no longer in force. Again, a specific repudiation of the OGL and any previous OGL and GSL and so forth. So they are specifically repudiating those documents to the extent that they're allowed to, which is, of course, what would be a matter for legal dispute, which is, again, super expensive. This agreement consists only of the terms expressly included herein and not any matter not expressly included herein. Like, say, the statements of the designers would be something there. For purposes of clarity, the introduction preceding the agreement and the comments and explanations accessible through links within the body of this agreement are not part of this agreement and have no legal force or effect. So all of these little commentary bits are not intended to have any legal effect. They're just intended to be explanation, and so you can't rely on them. So yeah. In accepting this agreement, you represent and warrant to us that you have relied only on the terms of the agreement and the advice of your own counsel, if any, and you have not relied on anything that is not expressly a part of this agreement. And I'm just going to note here, I am a lawyer, I'm not your lawyer, because no, I'm just looking over this, but this is not specific legal advice to your specific circumstances. If you are actually trying to do something under the OGL, talk to a lawyer and listen to the loud screaming that they will have about this. All right. Updates and/or amendments by Wizards of the Coast. It may be necessary for us to update and/or amend this agreement in the future, and we reserve the right to do so. If we do, we will provide notice of those updates. You have the right to either proceed under the terms of the updated or amended agreement or follow the provisions of Section 8 for termination, which means you don't get the right to proceed with the terms of what you signed. They're saying you either accept the updated ones or you cancel. All right. I see. Part of the bad things here is that it will make small creators and people who want to homebrew something afraid to do so, and that's a net loss to the overall community. Yep, I have canceled D&D projects because of this. So, yes, that is absolutely a thing because, yep. No waiver of rights. If we fail to exercise any right we have under this agreement, that failure will not prevent us from exercising that right in the future. Just because we haven't sued you for however long doesn't mean we can't. Just because we haven't canceled your document, at any particular time doesn't mean we can't. So, assignment. The rights granted to you under this agreement are granted solely to you, and you may not transfer those rights to another person or entity unless we give you written permission to do so. We, in our sole discretion, will determine whether we allow you to transfer the rights granted to you. So you can't sell your rights to publish anything and so forth. Severability. In the event that any part of this agreement is held to be unenforceable or invalid for any reason, the balance of this agreement will be enforced as if that part which is unenforceable or invalid did not exist. This is a super common clause. It basically... because typically if some portion, like some clause has an issue, you don't want to invalidate the whole document. All right. So I see if I produce system agnostic content for tabletop gaming, I will have an audience for it. I might still system agnostify some of the stuff I'm putting out. There's supposed to be an announcement soon. Expect them to walk pieces of this back and watch people without critical thinking and go, see, the leak was fake. Yeah, I'm going to explain what I expect I see them to do and what we should be demanding that they do. So, all right. Governing law, jurisdiction, and class action waiver. This agreement and all matters relating to its interpretation and enforcement will be governed by the laws of the state of Washington, and any disputes rising out of or relating to this agreement will be resolved solely and exclusively through individual litigation, i.e., no class action lawsuits. They do not want a class action lawsuit. So that is a, that's sort of a big thing there. And each party hereto irrevocably waives the right to participate in any class, collective, or other joint action with respect to such a dispute. You consent to the exclusive jurisdiction and venue of the federal and state courts located in King County, Washington, for the resolution of any dispute arising out of or relating to this agreement. Now, note, I am in Edmonton, Alberta, Canada. So if I have to travel to Washington to fight a lawsuit, then that's a whole lot of expense on me, right? So that's a big deal. Now you might be saying, why are they asking for litigation? Haven't we been seeing don't most of these ask for arbitration clauses? And we're actually seeing a move away from arbitration in a lot of these things. And the reason why is because people have figured out that if you get arbitrated by like thousands of people all at once, that it can be a major, a company can basically be arbitration bombed. So instead, they want it through individual litigation where they can push the costs onto you and where you can't form up as a class. The other thing is when we look at King County, I don't know King County at all, but I suspect that they picked a county that is very favorable to their particular arguments here. All right, so waiver of jury trial. We and you each waive any right to a jury trial of any dispute, claim, or cause of action related to or arising out of this agreement. Now, help me out, chat. Does Washington State have elected judges? I'm guessing they do, because most of the U.S. does. So I'm just looking. King County judicial elections. It does look like they have judicial elections. So, do you think, they're going to have all these judges who are saying, hey, we're running for re-election. Who do you think might be donating piles of money to the election campaigns of judges they think might be favorable? If you're thinking Wizards of the Coast, that's what I'm thinking too. People ask me, why are you against elected judges? Well, because you might have a major corporation who could use elected judges to push the scale. So, yeah. And I see people saying King County is Seattle, so it's where it's located. Yep, absolutely. But they also, are picking this. So it might be that they're picking it because it's close. It might also be that they're picking it because they think it's favorable. I also note the, who's the biggest employer in the region. I'm guessing it's not Wizards of the Coast because Boeing, right? There's some other big names in that area. So I don't think it's Wizards of the Coast. But Wizards of the Coast could certainly make donations to campaigns. So, yeah. Review by counsel. You agree that you have reviewed this agreement carefully and have had ample opportunity to obtain advice, which you are not getting here. This is me doing legal commentary. It is not legal advice at all. As to the meaning of the terms and agreements contained herein from such advisors, including attorneys, as you deemed appropriate or necessary. So this is them basically saying, hey, we're saying that you had the opportunity to have a lawyer, so you can't say you didn't understand what was going on here. See, biggest employer in Washington is Amazon. Yeah, nobody's competing Amazon for size. Microsoft. Yeah, there's some big names out there. So, all right. Now we've gone through, that was the non-commercial. Now we're going to go through the commercial. And you know what? The commercial is going to be a little shorter because I'm not going to review clauses that are the same as the ones we just did. Because quite frankly, my throat is getting a little sore and we will get really tired of this. So, and I see they can't enforce this crap. It's 100% illegal. I don't know that that's the case. I don't know that that's the case at all. I'm going to get to this comment. Well, maybe we'll address this right now. So could it be ignored and you could instead just publish content under the Creative Commons licensing instead? Creative Commons doesn't apply because they haven't Creative Commons licensed anything. What you could do is ignore OGL 1.1 and use nothing from the SRD. So you could, make sure that you stay away from that. So that's how you do that. I also see people saying you should be able to continue to publish under 1.0A, even though they're claiming that you can't. Quite frankly, I think that Wizards might win that argument. Now, when I say they might win that argument, they might not. But do you have the money to fight that argument with them? I don't think you will. And quite frankly, I think that they're going to push this argument through with somebody who has no money to defend themselves. And yeah. So that is just something to be aware of here. All right, let's go through and look at some of the both some super chats, but also just starred questions, because I said I was going to answer questions in this, and I've been sort of skipping through here, but let's sort of have a look. I see the OGL 1.0a does not give them the power to deauthorize, just to authorize new versions. It is silent on that, and so it is unclear. It's sort of difficult to say. Anyone know if Elon plays? Just saying. Elon Musk is not going to save you here. It's a nice thought, but he's not going to save you here. All right. So D&D Beyond released a Twitter statement saying, "We know you have questions about the OGL and we'll be sharing more soon. Thank you for your patience." Understatement of the century. Yeah, no kidding. In light of 1.1, how worried third-party producers who depend on third-party facilitators like DriveThruRPG to sell their product? After all, can't Wizards of the Coast demand those facilitators stop selling unlicensed content? They should be 150% worried, because that is exactly what Wizards of the Coast will do. So, yeah. Donna Parker, thank you very much for the super sticker. Thank you. Canman, is it really possible legally to cancel a previous document with perpetual validity by saying a new document cancels the previous one? What kinds of previous rulings actually support such a move? So the language that you'd want to use is irrevocable, but this is resulting from a bit of an interesting tradition an interesting evolution of contracts, which is that at the time the OGL was reduced or was put, people didn't really use the irrevocable language, and now it's considered sort of necessary. So it'll be a question of what the original interpretation was. People would be arguing that the original document was intended to be irrevocable, and Wizards would be saying, no, it wasn't. So that's a legal battle. And again, there is, most people don't have the money to deal with that. Do you feel that the royalties percentages are set so high to take all the income from any company that is larger than 2 to 4 employees to force companies to stay small or downsize? No, I think it's there for another reason. And we'll get to that, because I think there's another chat here that I will cover that we should address this in. So a court would have to adjudicate whether they actually could revoke 1.0 and relicense under 1.1. Yep, that is going to be a question, and it's going to be an expensive question. OGL 1.1 is not an open game license, so calling it an open game license is misleading to consumers. Isn't there an anti-misleading law for marketing and naming in the US? I don't think that that's really going to apply. They're going to say, listen, it's quite clear as to what it says. Just because you call it like open game license is just kind of branding. I don't think that there's any likelihood here. And I see here, Ryan Dancy already said it was intended to be irrevocable. Yes, Wizards would still argue that, even with him testifying, and they might win. Could this just be a poison pill? License terms so outrageous that it would force you to either use the D&D Beyond or negotiate directly with Wizards of the Coast so that they get their piece of the action. Yes, I actually think that there is not just that there's specific language in this that tells us that what they intend to do is to force people to make side deals, and to force people to make side deals that would get them to give up additional stuff. And we'll talk about that when we get to the commercial aspects, which we're getting to here. Also, does their attempted copyright infringement have any legal power outside of the US? Outside of the US is really broad, and different countries have different rules on contracts and licenses and so forth. So in Norway, you do not even have to list your name, much less state copyright, to have intellectual ownership. There's all sorts of different rules and so forth that will apply. I would assume that streaming and YouTube would also be covered under the commercial version, given that creators on those platforms usually get ad revenue or support from chat. It's entirely possible, although they have said that super chats probably wouldn't be covered, unless maybe let's say I said, hey, I've got some new material to share with you guys, and I will only do it once I see $1,000 in super chats. At that point, it might be covered. Who knows? We're into argument land. OGL 1.0a was a mistake because it made it look like Wizards of the Coast had rights they didn't have. That is partially true. I suspect that some of the stuff that that was out there is is like people just saying that they're invoking the OGL just as a defensive measure. Sorry, folks, I'm a little tired today, but I'm told tired Runkle is the best Runkle. They cannot cancel a perpetual license. Perpetual just means lasts forever unless canceled. Irrevocable is what we need to establish here. Lady or Peter Rain noting to Lady in Black, it will drastically remove the material available for DMs and players produced by third parties. Yep, I mean, I have an entire campaign setting that I am mothballing and I have a book about how to play rogues better that I am trying to decide what, if anything, I can do about it. So, yeah. All right. Knights of the Old Republic used the OGL in a video game. That was in 2003 before they even FAQ'd that it was just fine to use the OGL for video game production. Yes. Now the question is, lots of people are saying, will Disney sue? Is the House of Mouse going to save us? Can we rely on the dirty rat? And no, you can't, because the rat has ongoing agreements with Hasbro, who makes the toys for like Star Wars and all of the other content the rat puts out. Oh, right, that's Hasbro. Do you not think they're going to come to a deal that sells the rest of us out? You bet they will. So that's exactly nobody. The House of Mouse is not going to save you here. There's nothing in this that stops them from making your third-party content into unlicensed content by republishing it themselves. In fact, not only is there nothing that stops them, they explicitly grant themselves that right. So they explicitly and specifically give themselves the right to steal everything you have made. So can you put membership on? Done. Not membership, just subscribership. But if you mean, can I turn on memberships? That I'm going to have to do and, figure it as we go. Do you think Hasbro has borrowed/taken ideas from third-party creators up until now? Yes. If so, sounds like they've benefited from the original OGL for years and now want to change it all. Yes, and that's an important argument, which we'll get to. I saw it was raised in some of the comments that I did star here. I see here, could you produce your own D&D homebrew under Creative Commons? You cannot Creative Commons license anything that you are using the OGL for, because the OGL forbids you from having that or from using that. Does this also revoke the fan content policy of 2017? I don't know. There's clearly the contemplation of a fan content policy. We don't know if it's going to be the 2017 document or a new document entirely. So, all right, carrying on here. Jessica Michelle, just thanks. Thank you very much. It's greatly appreciated. Is there any grounds to argue that the intent of OGL 1 was for it to be irrevocable, even if not stated? Yes, that would absolutely be an argument. If I was being sued under this, you better believe that I would be making that argument. 150%, that would be an argument I would be making. I just don't know that I would win. I think it's a good argument. I think it should win, but I don't know if it could. Like, that is a different aspect there. Wizards of the Coast got in trouble recently with stealing Paizo art for their movie poster. Wizards of the Coast always tries stealing content. They have a lengthy tradition of trying to steal content. We should also fear Hasbro and Wizards of the Coast going after and buying any system that is made in response. We switch to World of Darkness. They come up and buy the company and force World of Darkness to be 1.1. That is possible. I hope World of Darkness doesn't sell. I like the setting. I like the game, but you never know. So Greg Gillespie is saying, I'm aware. Google me. So that is, I'm not sure what that is in reference to, but Greg Gillespie is Noble Knight Games, which is cool. So welcome. I'm just looking over briefly sort of a bunch of your stuff. A lot of this stuff looks super cool. So I will check that out a little more later. So Greg Gillespie, folks, do Google him because he's got a lot of cool content out there. So yeah. The Patreon situation is also messy if someone doesn't exclusively put D&D content on their Patreon. If half my Patreon exclusives are World of Darkness, What percentage of earnings does Wizards of the Coast want? I can tell you what they want. They want you to consider everything to be their content, to be their cut. That would be lawsuit material. So, all right. Can you point people to the Open D&D petition? I think I did. It's presently being signed by virtual tabletop makers and third-party content makers alike. Yep, I've signed it. The worst part of the Kickstarter thing is the backing funds counts as revenue, so it counts towards sales after too. So if you kickstart your book, you're especially hit. Yes, all of the money, like 100% of your Kickstarter revenue counts. And so, yeah, anything else that you could potentially see a double billing situation. I would certainly argue against double billing, but yeah. Wizards of the Coast isn't going to bother with litigation. They will attack and deplatform instead. I think they'll do both. I talked about that and mentioned that I think that they will look to get some precedents to their favor. Can you address what constitutes a derived work? If I write a novel with an elf and a dwarf in it, am I going to get a letter from Wizards of the Coast attorneys? If you write a book with an elf and a dwarf in it, probably not. If you write a book that's set in Waterdeep, definitely yes. There is a whole lot of wiggle room along the way, but you do end up with situations where essentially that a derived work gets to be a complicated thing. So one example of a derivative work is a translation. So if you translate D&D into Spanish, that would be a derivative work. And I see here, elf and dwarf is too generic. Yes. But if you put in like mind flayers and beholders, then you might get a lawsuit. And you can't use Elminster. Yeah. Also, that is, yeah. So, yeah. And I see Monkey Blood design only over $750,000. If you make $750,000 and $10, you only pay 25% on the $10. Yes. I will talk about that as we go when we get to the commercial aspects. I just want to cover through all this. If you created under another system and made a free document with items, spells, monsters, NPCs converted to D&D, would they still have a valid vector of attack? Maybe. Could they still take your IP and reprint it? If you put it under the OGL, then yes. So if you agree with the OGL, then yep, absolutely. There are different copyright laws across the world. If the new OGL is declared illegal, say in European Union, how do you think it'll affect the OGL? I think that basically you might end up with different rights in certain places. So that is a possibility there. So they specifically absolve themselves of any obligation to be fair. Yes, they do. Role of law. Could people publish D&D works under Creative Commons instead of using OGL 1.1? Not if they're using the material from Wizards of the Coast. In fact, if you use the OGL, you specifically cannot use a Creative Commons license on top of that. That is specifically forbidden. So I can't run a D&D stream on Twitch if it involves complicated social interaction and events that parodies real life. Arguably not. Like, let's say you wanted to run, let's say you wanted to run some sort of parallel to the antebellum South where, where the enslaved people rise up and, win a victory and, are clearly the good guys. Well, you'd be under real risk that they decide that that's, that's improper and so forth. So you got to be, you can't say what will or won't be affected. Is it possible to put your own license on your work that if Wizards of the Coast exercises these clauses or uses their your work, you can restrict them at all in return? Not if you are using the open game license. In fact, that is specifically forbidden to put your own terms on it. There's a Star Wars RPG that uses OGL 1.0. Do you think Disney/Lucasfilm will challenge this or make a deal behind closed door? I think they'll make a deal behind closed doors. I suspect that they've already had those discussions and that this is probably already lined up. The OGL 1.0A was given for consideration. It's not trivially ended. Yes, so this is... So copyright or contract law involves consideration, which is... both sides need to get something in exchange. The other aspect on this is the doctrine of detrimental reliance, which is that if you have, if you've relied on something to your detriment, it can make it harder for them to cancel. And I can't sort of explain all of that in full detail, but the fact that there's a lot of people who put out material for the D&D game at a cost to do so and relied on this, and creates an argument, at least, for this being harder to revoke. And so again, my argument isn't that people are going to lose in that battle. My argument is that it's going to be expensive, and a lot of people won't even be able to fight that battle. So that is, that's the issue there. Welcome to the Savage Worlds, everyone. Thank you very much. So yeah, we're in difficult scenarios here. They are canceling it. Section 9 of the OGL 1.0 says that as long as it's authorized, you can keep using. This new OGL unauthorizes the older versions. That's certainly Wizards of the Coast's argument on this. Would the OGL 1.0 apply to 5e back and 1.1 for 1D&D Beyond? No. Wizards of the Coast is specifically saying that there is no 1.0 after this. They're saying that once 1.1 comes out, that nothing else is coming out after that. Will Paizo sue or fight this since Pathfinder is built off the OGL? I don't know. What it looks like is that Pathfinder is probably going to revise its stuff and to basically hedge away from using anything OGL based at all. I see it's a colorable argument, and an attorney dismissing it out of hand isn't worth listening to, in my opinion. Yeah, I mean, there are good arguments on both sides, and anybody who tells you that they know which side is going to win is, quite frankly, lying to you, or is not good enough, or didn't really understand like legal uncertainty in first year of law school. Like, there are arguments on both sides. You could win, you could lose, but it costs $500,000 to play. So, yeah. How does this affect professional DMs that get paid to run games or teach people how to play? Unclear is the short answer to that one. What do you think the flow down terms would be, if any, for using Star Wars third-party licensee materials? Would I, as a player GM, need to adhere to the OGL 1.1? I suspect we're going to see some deals that have Star Wars stuff sort of brought in, because Star Wars, again, uses Hasbro as their producer. So, yeah, we're not going to see that. And I believe Paizo has said they have their own rule system ready to go if they needed to drop the D&D rules. Wouldn't surprise me. Contractual law is more about whether there was a meeting of the minds, so in a sense, intent matters. Still, a sophisticated party is free to object and not sign on to onerous terms. And yep, that's, ultimately, Wizards will say, listen, your option is not to produce content for this at all. So, yeah. Cobalt Press announced they are working on their own rules. Project codename Black Flag. I love the code name because, yeah. All right, so let's keep going and look at the commercial terms, because again, a lot of this stuff is repeated, so I'm going to skip over all the stuff that's repeated, but a lot of this stuff is is unique. So we're just going to look at the unique stuff here. So to be clear, this is repeated, but I'm just going to mention it. You can't even use the commercial terms for things like VTT campaigns or apps or anything like that, or computer games. They say you have to specifically work out a deal with them for those. And I will tell you that if you want to start up a virtual tabletop to compete with their microtransaction hell, that negotiation will basically go like this. So we'd like to, no. But surely we could, no, get out. They're just not going to, they're not going to allow that. And I see Pathfinder 2 only uses specific OGL content. It's identified in the books. Yeah, and they will probably be making a new version to strip all that out, because I'm pretty sure that Wizards of the Coast is not going to want, want that to be included. Greg Gillespie noting songs and dances. Really, this is them trying to be funny. They're not really looking at songs and dances. And in fact, I don't think it's just intended to be funny. In some ways, it's it's a sleight of hand here. And thank you for joining us. The slate of, the things that they're really looking at here, videos is something that I think that they're looking at in a big way. Virtual tabletops or VTT campaigns is something that I think that they're looking at in a big way. Computer games, same thing. And apps are, I think, their primary things that they're targeting here. That's what I think that they're really looking at here. I think that to a lesser extent, they'd be looking at novels and graphics novels. And I think music, songs, dances, and pantomimes is just intended to be cute. So really what they want to shut down is anything like, one of the things that drives people to D&D Beyond right now is that it's got a character creator, and their character creator on D&D Beyond, I'm going to be fair to them, it's pretty painless. It's pretty easy to use. I hadn't actually used it for anything until until Lawyers and Dragons, because we were using that as sort of the back end on Lawyers and Dragons. But I found it was pretty simple to make. Like, I had a character made on that in a minute or two. Like, it was real fast. But they don't want anybody making something to compete with that. And I see here they want to legally shut down TikTok creators from being negative. They're doing this right before the D&D movie to crush negative press. They might try to push that. They might. See, Greg Gillespie, if you need an app to create a character, your rule set is poor. Yes and no. Sometimes people really like that stuff. I mean, Shadowrun, I've played Shadowrun before, and I can tell you that making a decent Shadowrun character, I have always needed to use a spreadsheet for it. But I like Shadowrun. It's fun to play once you get past the character creation. But I also like games like, Blades in the Dark. I can knock out a character in 5 minutes. I can walk a newbie through making a character. Somebody who's never played a role-playing game in their life, I can get them to make a character for Blades in the Dark in 5 minutes. So real... Oops, I'm banging into swords here. If you're wondering what that clang was, I banged into this. So we've got a real, there's a real disparity there. So yeah, these apps, D&D is not trivial to make a character. It is, it's at the easy end, but it's not trivial. So they want to make sure that all of that has to go specifically through them, because that allows them to drive content through. All right. So licensed works includes a new element here that wasn't displayed or wasn't there before, which is that it displays the following creator content badge in the manner specified in the creator content badge style guide. And there's a drop-in picture. Now, I'm guessing that style guide is going to say it's got to be on the cover. It's got to be, up front and center. And yeah, the other thing is that they will probably have a licensing agreement for the creator content badge. And that license agreement will probably be a separate agreement as well. But they could decide to charge for it. They could say that, listen, if you want to make commercial stuff, you have to buy the rights to that badge. Otherwise, you can't use it. And that, that'll cost you $200. Pay to play is absolutely possible here and could very well be buried in this. And you could say, oh, well, they wouldn't do that, whatever. They don't, like, the way that this is phrased allows them to set this up for later. They could set this up and then a year from now, they could say, you know what, we're now going to charge you $200 for that creator content badge. And I mean, really, they could go even further and they could say, hey, we're going to charge you $200 and you need to use a different unique badge for every product you put out. So it's $200 per product. You see how that goes? They're including a real provision for to allow for them to get some stuff there. There is hope. RDR Books beat Warner Brothers. I should cover that case a little later, but right now we're gonna sort of see what we can do here. All right, we're gonna, again, a lot of this is sort of common. They also have the the aspect of using a different font, etc. Now, I note here that this is an interesting aspect. If the only way the reader can distinguish what you created from what we did is to check your license work against the SRD, you are not in compliance with the provision. This is from the commentary, not from the actual clauses, right? And they've said that the commentary does not form part and should not inform the court on that. What it actually says is identification of licensed content has to be done in a way that allows a reader of your licensed work to understand the distinction without checking any other document. I am a jerk, and if I was forced to use the OGL commercial, I would probably be throwing it in as a I would probably throw the entire SRD in and just say, yeah, Appendix A is the entire SRD, and now you don't need to check any other document. It's all in there. I mean, that's a little bit of, little bit of malice there, but we'll have to see there. All right. And I see here, Matt Colville just stated on Twitch, we're not signing this document. I don't think anyone would sign this agreement. It is a non-starter. Guess what, though? Matt Colville is big enough that he will probably get offered his own deal, and it'll be a better deal than this. So Matt Colville might be able to get some other agreement, but you can't. So, yeah. What if I run a Gene Funk created under 1A campaign on Twitch? Can Wizards of the Coast claim that? They might try. They might try. We'll see. All right. Leveling up under this agreement. So this is where we start getting into some of the additional stuff here. This agreement covers all commercial uses, whether they're profitable or not. Again, this is covering revenue, not income, right? So, it's your net revenue, not your gross. Note that if you appear, it's your gross revenue, not your net. Note that if you appear to have achieved great success, that is consistently meeting or exceeding the expert tier qualification from producing OGL commercial content, we may reach out to you for a more custom and mutually beneficial licensing agreement. This is something. Why the hell? So with all these people who had the full document and were releasing articles about this, why did none of them talk about this? Because this is a critical line here. And oh my God, why would... Guys, everybody else who talked about this so far that I've seen has dropped the ball. They know these terms are egregious when you get into the expert tier. They know that it is fatal to a content creator to reach that level. This basically says here that now they're going to come. And what is this more mutually beneficial licensing agreement going to be? Well, they're going to say, listen, we'll take the reins off to a degree that allows you to still earn some money on this. However, we want you to start producing content like we want you to license your popular characters for our virtual tabletop. We want to start making miniature minifigs out of your popular characters, and you've got to allow us to do that. And yeah, so this is basically this is that they are going to use this as sort of an extortion lever, that they are going to press people into those mutually beneficial licensing agreements so that they can get access to IP that they otherwise wouldn't be able to access, because otherwise you're just going to be into a fatal situation. So, yeah. All right. Initiate tier. If you've registered at least one license work but haven't generated 50,000 or more in total gross, so again, they're covering gross revenue from OGL commercial products in a given year, you are at the initiate tier. Now, keep in mind, total revenue doesn't necessarily mean that you've earned a single dollar. Let's say that I'm working on a book. I'm working on it, and I can tell you, art is not cheap. Artists want to get paid because, artists, they got to eat. It is what it is. And so, if your expenses are equal to your income, well, then your actual net revenue is $0, but you can still end up being, penalized on this based on that. If you are printing actual physical books, those books cost money, right? It actually takes a whole bunch of, nobody prints a book for free. Dead trees cost money. So all of that. Shipping costs money, all of that stuff. Intermediate tier. If your license works have generated more than 50,000 in total revenue in a given year, but less than 750,000, you are at the intermediate tier. And so each of these tiers, you might be thinking, yay, I'm gaining a level. And you know what? We're going to actually see sort of smooth-brained people out there saying, bragging, I'm an expert tier creator. Well, congratulations, you're getting screwed harder. Like, that's really what that'll come down to. And expert tier. If your license works have generated at least $750,000 in total revenue, again, that's gross. On a given year, you are at the expert tier. Gross in two ways. All right. So why the tiers? For one thing, it's Dungeons and Dragons, and even our lawyers play. It's possible we're not actually sure how to design something without some form of leveling up. All right, we are past 2 hours, so I can say this now. Wizards of the Coast, fuck you. Just straight up. Like, this, you weaselly little sacks of garbage. How dare you? Like, this is insulting. This is, eat me. Just, I really, you know what? I want to go further, but YouTube is punishing swearing, so I cannot tell them what I really think other than what I've just said. But, just seriously, go to hell. Yeah. But also, we're trying to minimize the burden on our creators as much as possible. No, you aren't. No, you aren't. This is not minimal burden. If you were trying to minimize the burden on your creators as much as possible, you had OGL 1.0a. That is minimizing as much as possible. Yeah. And I see, wait, really? YouTube punishes you for swearing? Yeah, they just changed the rules. And so they're going to punish swearing real hard now. So, as you'll see below, if you're in the initiate tier, all we need from you is some basic information about what you've created. Oh, this is insultingly misleading, and are offering for sale. And in fact, they need a full copy of everything you produce, which is not basic information. It's give us the stuff. Once you work your way to the intermediate tier, we'll ask you to provide annual financial reporting so that we can see whether royalties are due. So basically, they're going to become the tax man at this point. Reaching the expert tier means you will pay us royalties on your revenue over $750,000. If you're doing incredibly well, you might level up into a custom license. Yeah. So I see for your swear jar. Thank you very much. Because, yeah. I see, oh, poor EDB. That's like all of her videos. She actually had to change her intro because her intro has, facts, not effery. And so that had to go. All right. So level up into a custom license. That's a little like leveling up into being beaten to death out back in the alley. Like, if you're doing incredibly well at the casino, somebody might rob you for your profits. Congratulations. No, like, no. All right. So registering and reporting. Registration, no matter what tier you're in or how much money you believe your product will make, you must register with us any new license work you intend to offer for sale by going to insert detail, because this is a draft. They'd have a link here on the actual thing there. I see more cash for the swear jar. Bugger off, Wizards of the Coast. Thank you very much. Yeah, if you're doing incredibly well at the casino, they'll just kick you out. Yeah. Yeah. So filling out the form there and including a description of the license work. We'll also ask for your contact information on where you intend to publish the license work, and its price, among other things. Note that a bunch of this stuff might otherwise be considered trade secrets, because things like, hey, I plan to publish this, and here's where I'm going to publish it and for how much, before you publish it, can actually be pretty important information, because that guarantees that's, that would allow somebody to undercut you and so forth. Rod Batten, thank you very much for voicing what everyone else is silently screaming. Yeah, this is bad. See, so the system I'm building will have to be made completely separately from D&D. It originally started to give more choice to spells and item creation. I think we're going to see a lot of new game systems starting up here. So, and I love Tired Runkle. Yep. All right. So, reporting. As soon as you make $50,000 in gross revenue for a particular year on products covered by the OGL commercial, and it's used in this agreement, revenue means any income you make from selling a work licensed under this agreement, or from crowdfunding those works, or any other income source. Any other income source gets interesting, because, like, say YouTube, like, hey, is this any other income source? Arguably. So they're gonna, this could really affect successful streamers in a big way. And I see 2024, the year of 10,000 systems. It might well be. We might see a whole bunch of them. All right. So once you do that and reach the intermediate tier, you will need to method for reporting income. So that's again, this is a draft, so that's all going to come out, but they want you to report your income. In addition, you'll need to provide us with your year-end numbers by February 15th of the next year. Now, the method of reporting income is interesting here, because we don't know exactly what all they're going to specify here. And it's entirely possible that they will ask for things like breakdowns of your costs and breakdowns of your income by source. Like, hey, how much are you making from Patreon? How much are you making from Kickstarter? How much are you making from, DriveThruRPG? And normally a ton of this stuff is stuff that you would never actually share with another person, because this is the kind of stuff that is, like, typically stuff you'd keep confidential and secret. In fact, I've covered on Runkle of the Bailey, my other channel, lawsuits with GWAX. And GWAX has been indicating that, they consider this stuff to be part of trade secrets and confidential information that they're suing someone else for supposedly relying on. So, yeah. Who do they think they are? The IRS? Yes. Yes, that is exactly who. All right. Royalties. If and only if you are generating a significant amount of money, over $750,000 per year across all licensed works. And keep in mind, that's gross. That's not your net. The revenue you make from your licensed work in excess of $750,000 in a single calendar year is considered qualifying revenue, and you are responsible for paying us 20% or 25% of that qualifying revenue, as explained in section, etc. Now, and I see here we've got a little more for the swear jar. YouTube can't stop me from swearing. So let's talk about this. So let's say I have pretty like margins on role-playing game books are real thin. So in actual practice, you're probably talking about like, you know, I don't know what they're making on Blades in the Dark in terms of their margins. I think they might be lucky if it's a 15% margin. So what happens if you have, but let's assume, and I'm just seeing if, I'm just throwing it into Google real quick to see if anyone's got an estimate of as to what actual margins are for profits here. Just what are the actual? Does anyone have this? So yeah, the margins that we're talking about on these are actually fairly thin, and a lot of the money, like when you see the sticker price on a role-playing game book, a lot of that sticker price is not going to the creator. A lot of the sticker price is going to all sorts of intermediaries. So, if I make a book, and again, I'm got this close to hand, so if I made this, and I didn't make this, but I'm talking about a hypothetical. Somebody's printing this, and the person who's printing it wants as much of the money that is available as they possibly can. So they're going to charge me as much as they possibly can to print this. And, I'm going to be forced to pay them a certain amount. That is money that sort of disappears off the margins. If I'm putting this up on an online site, they're going to want a bunch of the money that, is used. Art that you have in your book costs money. Formatting. You're probably hiring somebody to do your page layout and to make it ready for print. Costs money. All of this stuff costs money. And so, I mean, a really good margin, a fantastic step over your own mother to get margin in this might be 40%. But more realistically, you're probably talking about people putting out stuff on margins that are like 2.5%. The margins on role-playing game books are super, super thin at the end of it. And most people in the sphere are putting stuff out because they love doing it, not because they think they're going to get rich. It's very rare that people will get super wealthy on all of this. So if you're putting out $750,000 worth of product in terms of store sales, but your actual margins are 15%, which would be a great margin, you're going to run into a really interesting problem here. So let's say your margins are 15%, right? And you are selling stuff on this system. At $750,000 of gross revenue, you hit a wall where suddenly it actually costs you money to sell more books. You're not making more money at that point. You are actually losing money. And I see here, how much is the Wizards of the Coast margins if they think 25% of the gross is remotely reasonable? They don't think it's reasonable. They think they have to know that this creates a situation of this will kill your business. And this could end up having serious problems. Like, let's say you're running a Kickstarter for a new book and your margins, as mentioned, 15%. And you're thinking, this book will do really good. I'm thinking it's going to do 150,000 in gross revenue. And what, 15% margins. I'll just do some quick math, because lawyers. I'm going to make 22,500 off of this, right? So fantastic. But then your Kickstarter somehow does way better than you expect. And your Kickstarter jumps up to 2 million in gross sales. Well, now you are going bankrupt. You literally cannot survive at that. Even if it's on Kickstarter and you're only paying the 20%, you go bankrupt at that point. So this creates a situation where if you are selling a certain volume of stuff, I don't think that Wizards of the Coast thinks this is reasonable. I think they know that this is a bomb that they're building into their system. They're building in a bomb such that if you're going to sell a certain amount of stuff, you cannot survive without cutting a custom deal. So, and they see it's to keep another Paizo from happening by discouraging any medium to large creators. Yep, it's if at the point where you're going to be achieving a certain level of success, they get to decide whether you succeed or fail, because if they don't give you a custom license, you fail at this point. Or you're in a situation where where essentially you have to come to them to make a deal. And, you'll have to come to them hat in hand and guess what kind of license terms you're going to get, on that. And then they'll say, okay, we're going to allow you to continue to exist. So this is absolutely, they're building a time bomb into this. And so if you start to see how you're doing, then yeah. With them gathering the financials, they can see how they need to change it to make you fail if you haven't already. Yep, absolutely. And the other thing that we can see on this is that they're going to be able to identify like rising stars. And if you start to really succeed in this industry, they can take steps to kill you, like just say, we're not licensing you anymore. Or they can take steps to destroy you by saying, hey, we're going to just take all of your content and resell it more cheaply. So it's really, really, really terrifying here. So for the swear jar, because we're all wanting to tell Wizards and Hasbro where to stick it, you bet. So this is really, really bad. And the people that missed this aspect of, we will, you might level up into a custom license, really have failed to understand what the whole point of this is. There's lots of commenters out there online. I haven't seen any of them really discussing this. And I'm going to probably make a separate video just talking about this element and how they have to know what they're doing here. I see here, I need to ask a publisher friend, but there's no way they have more than 5% margin on small volume print. Even 5% sounds large. Yeah, I think 15%. I can tell you that there's probably a lot of people making D&D books out, or various books out there that would probably sell their souls to whoever to get 15%. So Houndsong Games mentioned that it doesn't look like there's a way to level down. That actually is interesting. It looks like it's in a given year. So you would level down if you stopped making money. So, yeah. People really think that if they do or say nothing, it'll be fine because their games will be fine. They do not realize how this affects free online content and SRD pages. Yep, absolutely. Anybody who's telling you that you're too pessimistic about the impact is probably misleading you here. Wonder when the EU's version of OGL 1.1 shows up, because I see a few things in here that are simply aren't enforceable here. I would love, Nicholas, we gotta have a talk on that, because yeah. I see, how is taking your content, they're taking your content, not copyright infringement? Because by agreeing to this license, you have agreed to let them. You've given them permission. So it's not copyright infringement. It's just you making a deal there. What Wizards of the Coast didn't foresee is that you never mess with the rules lawyers. They've got their own lawyers. So, all right. Delayed collection. Though this agreement is effective January 13, 2023. Now, we don't actually know if that's going to be the effective date. They plan to release this to the public on January 4th, and they haven't released it to the public. We've got this through a leak. I'm guessing what happened is that they sent this out to a few content creators and a few people saying, hey, how about this deal? And those people probably came back and said, yeah, so we ran it past our lawyer. And what our lawyer said was, just entirely bleeps. Like they just ranted for 30 minutes and none of it could go into a YouTube video because it was entirely elaborate profanity. And so, no, we won't be signing this. And, I'm guessing that that's why we didn't see this released on January 4th. So, so they note here, no royalties will be due on any income earned before January 1st, 2024, no matter how much that income is. I've seen people misreporting this. I've seen people saying, hey, that this means that you'll still have to pay the money, but it won't actually go, go live until then. No, you're not actually going to have to pay that. So that is important. We want to give our community a lot of lead time to plan for this. For clarity, all other requirements of this agreement are in effect from the time you enter into the agreement. Now, note that they wanted to give people a week for this. So I've seen people saying, oh, this is just a draft. It doesn't matter. You don't need to push back right away. Push back now, because if you don't, when this lands, there won't be enough time to fight it. Keep phoning them. There's lots of resources on how to challenge this. Keep going. Keep challenging this. Payment tiers. At the initiate and intermediate tiers, you will pay a 0% royalty. Okay, 0%, I like those numbers, which is what the OGL 1.0, so 1.0a had. At the expert tier, you'll pay royalties as follows. If your licensed work is crowdfunded or sold via any platform other than Kickstarter, you will pay a 25% royalty on qualifying revenue. And if your licensed work is crowdfunded on Kickstarter, our preferred crowdfunding platform, you will only pay a 20% royalty on qualifying revenue. And this is another of these things that indicates that this is, that this is a real document, because Kickstarter came out and explained why this 20%. Kickstarter saw this and made a deal with Wizards of the Coast. So until this goes away, F Kickstarter as well. I'm not buying anything more on Kickstarter, and I can tell you, I have a real hankering to buy a laser. It's called the Laser Pecker. It's kind of a dumb name, but they've got the Laser Pecker 4. I have kind of a hankering to get one. I would buy one, but I'm not going to, because it's on Kickstarter right now. So, and I'm not messing with Kickstarter right now. I see people have confirmed that this document was sent to them as an executable contract. This is not a draft. So, yeah. See, only 20%. Holy S. Yeah, I mean, Kickstarter thought they were getting a great deal on this. Kickstarter is dumb. Kickstarter should realize that 20% is still project fails. So, Kickstarter, you got played, and also you sold us out for nothing. You sold us out for nothing here, and I'm not happy with Kickstarter. If you have more than one licensed work, this is a critical provision here, folks. And only some of your licensed works are funded through Kickstarter. You will pay royalties on your qualifying revenue based on the proportion of your total revenue that was earned through Kickstarter. For example, if you sell 2 licensed works, one of which earned $600,000 on Kickstarter and the other of which earned $200,000 off of Kickstarter, you will have $800,000 of total revenue and $50,000 of qualifying revenue, of which 75% came from Kickstarter and 25% did not. So you will pay a royalty of 20% on $37,500 of your qualifying revenue, $7,500, and a royalty of 25% on the remaining $1,250 of qualifying revenue. So this is basically saying that it's not $750 per product, it's $750,000 per anything that you sell, like all of it in total. Has Critical Role made a public comment on this yet? No, they have not. They have been cowardly. So yeah, Critical Role, I'm not messing with Critical Role until this is done. I expect them to stand up for their community, because they got to where they are relying on OGL 1.0, and now they're in a position to sell the rest of us out if they want. And no, I'm not putting up with that if that's what they're going to do. Yeah, I see Mercer has allegedly liked some tweets. Stand up and do more than that. So now, Wizards has offered to help you calculate how much you owe them. And there is no way I'm looking to to help them calculate how much I owe them. But yeah. Again, all of this is really kind of irrelevant because that 20% will kill you. Will absolutely destroy your company. So royalty payments for a given year are due on or before March 31st of the succeeding year. For example, if $1,000 in royalties are due for 2024, you must pay us that $1,000 before March 31st, 2025. Please pay us on time. If you don't, we reserve the right to charge interest at either 1.5% per month or the maximum amount permitted under applicable law, whichever is lower. I can tell you the maximum amount permitted under applicable law is probably lower than 1.5% per month. This is like putting it on your freaking credit cards. So, yeah. Please pay us fully. If you don't, in addition to paying the unpaid royalty and any applicable interest for late payment, you will be charged our actual cost of reviewing your records if you underpaid our by 10% or more. So you're going to have to pay for their accountant, which is going to be stupid. I see the interest rate on late payments is almost decent, except it's per month. They're going to hit you with interest per month. Most interest rates are on a per year basis. Per month is interest is nuts. I don't know what that looks like on a per year because I'm a lawyer and lawyers are renowned for being bad at math, but that looks bad to me. So you must keep complete and accurate records sufficient to confirm your compliance with this agreement, including calculations of amounts due for a period of 3 years after each royalty period. In other words, if you have revenue from licensed works in 2024, you'll need to keep those records through January 1st, 2028. Does this sound like the tax man? Yeah, and I see 1.5% monthly is 18% annually. 18% is pretty ridiculous. I can tell you that if the interest rate, if I owe money on a judgment here, is way below 18% because 18% is nuts. And I see, is it compounding interest? Yes, it is. That would be compounding. So, yep. Yeah, so worse than 18% as it would be calculated monthly. So, yeah. I don't know what it would be because I got to do compound interest calculations, but oh my God. If we ask, you will provide us with copies of your records relating to the revenue earned from your licensed works, including those records you used to calculate the amount of royalties due to us, so we can confirm the calculations of those amounts and audit your royalty payments. Again, if you're feeling like, this is the IRS, you bet. If any mistakes were made, you agree to promptly pay us the amount that was not paid, plus any interest due at their ridiculous rate, which somebody's saying it's 19.5% of its compounding. Again, that starts sounding like credit card interest, right? So, yeah. I see if Critical Role agrees, they essentially hand over all their products, except those not profitable for Wizards of the Coast, to produce themselves. Critical Role would agree to a deal that does not include all of those provisions there. Critical Role would, agree to something that gives them a better benefit than this. All right. Comments. We want to be crystal clear about this. No, you freaking don't, you lying sacks of monkey droppings. Royalties are only due on revenue above $750,000. So if you make $750,001, then you owe us a grand total of 25 cents or 20 cents if through Kickstarter. We know this calculation can get more complicated if you have some works funded through Kickstarter and others that aren't, but please don't stress about it. If you have questions about your particular situation, reach us to it at email and we'll work them through together. Isn't that nice? They'll help you calculate how much you owe. Yeah. Fundraising. We don't object to you crowdfunding your licensed works, but we need to address concerns about overreaching and prevent the funding of infringing products. Because of that, this section has very specific requirements. If you're planning on crowdfunding, you must read this whole section carefully and be sure you are fully compliant with it. You may crowdfund, provided that you may only crowdfund the production of licensed works. No infringing materials are giving out as perks or rewards. The primary product for your campaign must be a licensed work, such as a campaign setting. You may have stretch goals that are not licensed works, provided they do not infringe upon our intellectual property. For example, a dice set with your company's original logo, but not one with ours, is permissible. You may also have stretch goals that would otherwise qualify as licensed works, such as modules and adventures. Those additional modules and adventures do not have to be registered separately with us, unless and until you decide to sell them separately from the campaign. Yeah, people have been presenting it as though if you make 750,000, you owe 25% of that. That is not the case. That is not how that would work. All right. Your entire campaign, including stretch goals, is considered one product for the purpose of the royalty threshold. If your campaign raises $750 and $1 or more, you pay royalties on that last dollar because the product you're crowdfunding exceeds that revenue threshold. That said, any revenue for any add-on materials that backers separately purchase is not considered qualifying material or qualifying revenue unless the add-on is a licensed work. So I'm not going to go through their examples because their examples are long and so forth. But basically, if you have this where there's an additional sort of how to phrase this. So if you're selling a book and then as the stretch goal, you're going to throw in some dice, then it doesn't matter what percentage of this was the dice, or even if you're taking a loss on those dice, all of that counts. But if you have, hey, we've got, the campaign setting of Breaking Waves, which is my campaign setting, and, we sell separately that you can get some special Breaking Waves dice, then that wouldn't count. That's sort of the simple explanation for that. So warranties and disclaimers, all of that is the same. Termination, all of this is the same for breaches. Again, the same thing about, racist, homophobic, etc., which doesn't have to be racist, homophobic, etc. It could just be that you are making Pathfinder, which they're going to decide is, racist against, I don't know, summoners. So, yeah. Sometimes great minds think alike. Yeah, so the same sort of aspects here. Again, this includes all the nasty stuff from before. So they have basically said, hey, listen, we give ourselves the right to just decide that you can't sell your content anymore, but we still can. So at that point, and they can do that based on you having provided them with your revenue details, right? So you've actually told them your revenue details and said, hey, this is how much we make. And so Wizards can say, hey, you know what? We're just going to steal the top 10 products. Top 10, they're ours now. And we're going to put them out in a book, it'll be the Book of Complete Bastardry. And it'll just be a compilation of the top 10 products from Kickstarter. We're going to pay nothing to the original designers. And instead, we are going to, we're going to include a special section talking about how those designers are garbage people and we hate them and we hope that they fail. So, yeah. Anyway, I got to wrap this up fairly quickly here. Just looking over things. Let's cover the remaining super chats here. I see Froggy Girl. Did I miss the whole thing? Yes, but you can catch it on replay. Is it normal to waive your rights to a jury trial? It is fairly common. Jury trials are more expensive for various reasons, and waiving your right to a jury trial tends to benefit the side that might be less sympathetic. Matt Colville just stated on Twitch, we are not signing this agreement. I don't think anyone would sign this agreement. It is a non-starter. Yep. Emma Z, thank you very much for the super sticker. What does this imply for resources like 5e Tools? 5e Tools is already infringing. Wizards of the Coast wants to sue them out of existence if they can. The Tolkien Foundation foolishly agreed to accept a share of the profits for Lord of the Rings movies and had to sue when they got about $300. Yeah, never. Yeah. However, when you're talking about role-playing games books, you got to keep in mind that the margins are super small. And so when you ask for a cut that exceeds people's margins, that is basically saying that those have to fail. This one I already covered, but Niklas, let's talk. Largo 1.17, I should have covered this sort of sooner when it came up. If you use nickels for your swear jar, this might cover some of your real thoughts on all of this. Yep, absolutely. And for the swear jar and as a thank you. Well, thank you very much. And I see sent you a Twitter DM. I will respond to that soon. I've actually got something I've got to be at in about 10 minutes. So I'm cutting myself a little fine here. But so yeah, we've gone through all of this. All the people saying it's not so bad. It's exactly worse than you think it is. So yeah. Any thoughts on what this will do to the people who make and sell minis online? It may put a lot of them out of business. They said that the OGL doesn't cover minis, but copywriting the concept of a plastic dragon on a base is sketchy. Yes, it is sketchy, but it gets less so when you start to start looking at specific elements that are D&D related. So yeah. Have I seen Kobold Press's statement? Not yet, but I will probably look at it at some point and possibly do a video. So thank you guys for watching. As I said, this is, just sort of trying to cover this as best I can here, but let me know, there will be a comment section below. If there's a question that I haven't covered here, I tried to cover all the questions in the chat, but if there's something I missed that is on your mind, let me know and I'll try to get to it. It might be a follow-up video. It might be something where I reply in the comments, but I will try to get to it. All right. Thank you guys. And see you next time. Hit the like button, share this one with your friends, all of that stuff. The YouTube stuff is super important. All right. See you, folks.